Ugh. Bene.
ಅಟ್ ಎ ಟೈಮ್ಗೆ ಒಂದೇ ಲಾಗಿನ್ ಆಗುತ್ತೆ.
Total years of service, 4 years.
With your permission, Lordship, I appear in an habeas corpus petition. The detinue's mother has passed away yesterday. The matter is listed tomorrow. We were filing an application for his provisional release. We went to the jail authorities and asked for provisional release under emergency parole. There's nothing in writing, but they are refusing to entertain it because of the detention order, Your Lordship. At 2:30, if I may request.
See, but would that be maintainable here?
Your Lordship,
You not make a prayer before the concerned court.
He's supposed to make an application before the jailer.
Your Lordship,
Parole and maybe an interim bail.
Your Lordship, yesterday, once I was intimated about this fact, I had directed the petitioner's, the father, to file a parole, emergency parole application before the jail authorities. Of course, there's nothing in writing, but I was told that they are not entertaining it.
You must move fast. When did she expire?
Yesterday, Your Lordship.
Move fast. See, we have a limitation. We're just expressing you because this is an habeas corpus. Getting the point? And is he under arrest? You don't know.
He is preventively detained under the Gundas Act.
Oh, preventive
Detention,
detention.
yes.
He is preventively detained under Gunda Act, Your Lordship. The matter is to be taken up tomorrow, Your Lordship.
What do you say?
Unless they can make an application before the jailer, my lord, superintendent.
For the jail authority.
Please, my lords.
Your Lordship,
But would they do it? If they don't do it, the purpose gets,
We look into that, my lord. We look into that.
Well-
We look into that and we'll just pass instructions accordingly, my lords. Once they make an application,
Your Lordship,
does he
yes.
have any powers?
they have the pass.
Yeah, he is under preventive detention. Once
Please,
he
my lords,
has-
even though he's in preventive detention,
Your Lordship, yesterday,
emergencies, my lords, they have pass to release him for a day or a two.
yesterday I had
With the
advised
police.
my client to file an emergency parole application under Form 11 of the prison rules. Unfortunately, I could not accompany them, but I was told by my client, that is the petitioner, the detainoo's father, that they tried submitting that application, but the police authorities said, because there is a preventive detention order, there's nothing we can do. Of course, I have nothing in writing to substantiate this, but these are the instructions of my client, Your Lordship.
I'll seek instruction, come back by 2:30, my lords.
This is a memo.
This is a memo, Your Lordship. I'm also getting the death certificate from the hospital. I'll file that along with the interlocutory application before this court. May I request your honors to take, your lordships to take it up at 2:30?
Please, my
Take
lords.
it up.
Meanwhile, I'll take the instructions.
You see, we want that memo must say so.
I'll,
About the demise. And you are claiming only for a day or two.
yes. Your Lordship, I'll ensure that the petitioner files a verifying affidavit and the death certificate issued by the hospital is also placed
We
before you.
want Everything should be here,
Yes,
but when will you get the death certificate?
they are on their way, Your Lordship. I'll have it in the,
When you get it, just mention it, we'll just.
Primary declaration of doctor is enough, my lords. In
Pardon?
that case, the primary declaration of death by a doctor,
You also take instructions.
please,
Possibly we'll have it at 2:30.
yes, Your Lordship.
please.
I'm grateful, Your Lordship.
But we want death certificate,
I'll ensure that it's filed with an affidavit before, my lords.
with an affidavit.
Yes,
And naming the detainee's name also.
yes, I'll do that, Your Lordship. I'm most grateful.
Have it after, just show me. No, we will not do one thing. Just let the death certificate come, then only we'll process it. Okay? Let the death certificate, then we will process it. The pagination changes between the list. Why list would not be. See, this is different. Yes, come.
That's permission, serial number 35, my lords. I am for the respondent. Petitioner, appellant's counsel is not keeping well, my lords. He has informed in the morning, Mr. Somsekhar is not keeping well.
You are for or the,
I am for the respondent, my lords.
Okay.
It's a 17B application, some date may be given after 2 weeks, my lords.
now, who is for the petitioner?
Appellant is Somsekhar, my lords.
What is the difficulty?
Some heart problem, my lords.
Who's,
He underwent, Somsekhar,
oh,
the counsel for the appellant.
just say this. We have been informed that the counsel for the appellant is indisposed.
Fine.
First of re-notify on.
25th, my lords.
We'll just give according to our convenience.
Sir,
17B,
17B application, I have filed, my lords.
post award.
Yes, my lords.
For 17/9, sir.
Great. Some earlier date, my lords, because it's almost 3 years award passed. Some little,
Just see, ma'am, one first week or first week
Sir.
possible.
Sir, 5th of September.
great.
Serial number 1. Shri Venkatesh.
So office objections. Office objections to be removed within 4 weeks. List on.
Serial number 2.
During the course of the day, my lord, application, full cost title to be filed.
For the petitioner, appellant submits that the office objection shall be cleared during the course of the day.
Please.
We notify all.
10-9. Previous to 10-9, okay, sir. Serial number 3. Shri Viresh Budihal.
The Lordship appearing for the appellant in this matter. Uh, The appellant has given instructions to file the withdrawal memo because the competent authority has given, has received the government instruction that to withdraw the present writ appeal. So I'm filing the withdrawal memo and there was also cost imposed
For whom?
for the appellant. Yeah.
Appellant.
Yes, yes, Lordship.
You have instructions to withdraw.
Yes, Lordship.
Your wakalat is here.
No, seniors wakalat is their Lordship.
No, who has signed this?
She learned advocate Sri Viresh Budiyal.
No, his wakalat is here, na?
His wakalat is their Lordship.
Just say that a withdrawal memo has been filed by the counsel for the appellant.
Rami Reddy, Lordship.
Just take down the name, ma'am. Mr. Viresh, name is here.
Viresh R. Budiyal is the senior advocate, Lordship. Senior in the sense, he has the wakalat in the present matter.
So he's not a designated senior.
No, not designated.
Just take his name. What is his name?
Shri Viresh
He
Budiyal.
signed it, no?
No, I have signed, Lordship. He has given the instruction to file it.
States that for appellant duly instructed by so and so. What is his name?
Shri Viresh
Ah,
Viresh
Viresh R.
Budihal.
Budiyal, which reads as under.
Serial 10-9, appadi, sir.
You should be forthright. Fourth in the sense, yes, we want to withdraw it. Feels to withdraw it. Accordingly, the appeal is dismissed. as
Lordship, there
withdrawn.
is also a cost imposed for non-compliance of the objection, some 5,000 rupees. So pray for waiving of the 5,000.
We'll do one thing. Was notice issued on this?
No, Lordship, no.
Let's see how was the cost imposed?
For
The-
non-compliance only, the 5,000 rupees was imposed, Lordship.
Did you remove the objections?
No, Lordship.
Simple, the order says 2 weeks' time is granted as a last chance to comply with the office objection subject to appellant depositing. So that chance was subject to you depositing. You have not removed it. So no need to pay. Say subject to.
Thank, obliged, Lordship.
Dismiss as withdrawn.
Serial number 4, Shri K. Srinivas. 4.
I may be permitted to take out notice on the standing counsel of the respondent power, the bank. Not twice notices were not taken, but not served on the respondent.
Notice be issued to respondent number 2, returnable law.
22-10. Serial number 5. NR.
You appear for the respondent.
Petitioner. Petitioner.
Let notice, fresh notice be issued to the respondent, returnable law.
23-10. Serial number 6.
This matter and for the
Gopal.
appellants, my lord.
You were to file the translation.
Yes, my lord. They have to file, my lord.
Who was to file? Who were to file the translation?
They have to file, my lord.
Way after.
The objection, the.
For
you say
Dasra
this-
procession,
Order may be passed.
Objections
10 days.
raised in respect of 1/20, IA 1/24, and also in respect of translation of the Kannada documents. Be complied with how much time?
1 week time. Next week.
Date will be
Weeks.
fixed.
Date may be fixed.
2 weeks. Just give
Date
it.
may.
28/8.
Main matter may be taken up in this, but there's an urgency.
Which main matter?
The main matter, my lord.
There is something.
In which matter? Item 6?
Sorry.
7.
Your lordship's kind permission.
Serial number 7.
My lord, some time may be granted to.
Let fresh notice be issued to the respondent returnable on.
24/10.
Obliged,
Serial number
ma'am.
8. Serial number 8. for
Serial
memo
number 8, I appear for the appellant, my lords. I filed memo for withdrawal. The writ petition has been disposed of.
You want to withdraw this?
Please, my lords.
This shows that, no? A memo for withdrawal has been filed by the counsel for the appellant, which reads as under. To stop, she reiterates the prayer of the memo. To stop, the appeal is dismissed as withdrawn.
Obliged.
Serial of withdrawn. Serial number 9.
Appear for the appellant, my lord. But there's one office objection that that has been raised, for which I've written a counsel submission, my lord, for your lordship's kind consideration. But this is a writ appeal, my lord, filed against the batch of matters, wherein, my lord, the learned single judge has passed a common order. So in my writ appeal, my lord, I've stated the individual cause title, my lord. May I draw your lordship's kind attention to page number 8, my lord, of the writ appeal, volume 1, my lord. I have stated the individual cause title, and this is as per the rules prescribed in the writ proceedings rules, my lord. But registry, my lord, has raised one objection stating that common cause title has to be furnished. Common cause title has to be furnished. My submission, my lord, is as per the format prescribed in the writ proceedings rules of this honorable court, my lord.
But tell us one thing,
Yes.
I don't know, we have to see those rules also. But this writ appeal is, the order is a common order for all the appeals, all the writ petitions. But insofar you are agreed by the order which has been passed in your writ petition,
In all of these matters, my lord.
all of these.
It's a common order, my lord.
No, right, it's a common order disposing of, deciding, let's assume 10 writ petitions. But you would be concerned with your writ petition.
The direction that is issued by the learned single judge, it's pertains to all the writ petitions, my lord.
You
As
are
against
agreed by,
this-
but did you claim those reliefs which have been rejected or granted, against which you are aggrieved?
My lord, I was the respondent before the learned single judge,
You are the respondent.
and I was a formal party, my lord, before the learned single judge.
So what do you want us to do?
My lord, submission that I'm making before your lordships is that the cause title that I furnished before your lordships in this writ appeal, it's as per the rules prescribed in the writ proceedings rule. Therefore, the office objection may kindly be overruled.
No, this memo, cost title is as per your writ petition.
Yes, my lord, it's as per the writ petition, my lord. And it's as per the rules prescribed in the writ proceedings rules, my lord. So the office objection may kindly be over.
Otherwise, what is the objection of the registry? The memo of, in all the writ petitions needs to be given.
My lord, I have furnished all the
You have given.
memo. What the registry is saying is the respondents being common, they have to be stated in one single page. Therefore, it will be convenient for this honorable court while dictating the judgment or while recording the judgment. That is the objection, my lord. And there is also one practical predicament, my lord. If I have to change this cause title, I'll have to waste another 3,000 pages, my lord, for I'm in your lordship's hands.
You are the common respondent in all the petitions?
Indeed, my lord. Indeed.
Then they may be right.
My lord, but I've stated the individual cause titles of all the writ petitions,
All the.
all the writ petitions, my lord.
But it's a one common memo?
Yes,
No,
my
or
lord.
individual memos? Or individual?
Yes, for example, my lord.
Yeah, we have seen that. So what is your understanding of the objection?
My lord, my understanding of the objection is that insofar as the respondents that are common, a concern, for example, my lord, the Union of India, the Ministry of Finance, they have to be given a continuation ranking in the parties for all the writ petitions that are concerned. That is not prescribed, my lord, in the writ proceedings
Like
rules.
R1 or appellant 1 and 2?
R1, my lord.
R1.
R1 in
C.
writ petition number so and so, R1 in writ petition number so and so. So they're expecting a common cause title insofar as the common respondent.
And what would happen to the other respondents?
Other respondents would be given,
Follow them.
follow them.
It appears because the appeal is one,
Yes,
it should be a one memo for memo of parties. And which should be in continuity, it appears. Like Union of India, all Union of India should be bunched together.
yes, ma'am.
Then the individual respondents would come.
Yes,
So that there is one common, possibly against that particular respondent, you will say, so what was his status?
yes,
The writ petition.
indeed, my lord. That's
what they
that
say.
is the objection.
But otherwise, how would you reconcile when there is one appeal and different memo and different respondents?
Yes, my lord.
See, we'll tell you why.
Yes,
There is a respondent one. Let's just say, let's see this,
Yes.
page 11.
please.
No, let's see page 9 first. You have 9,
Yes, my lord. Fine.
this gentleman 1.
Yes, my lord.
Now, if you just turn over to 11,
Indeed, my lord.
there is again respondent number 1.
No, my lord. In page number 11, my lord, TransUnion Sibyl is the appellant before your lordships, who
Okay,
I'm
very good.
representing.
Okay, then let's turn over to page 12.
Page 12, my lord. It's a different respondent. Therefore, my lord, that my
Could
respect,
be a confusion at a later stage. If I have to ask you who is respondent number 1 in this appeal, what will you say? Either you will say X or you will say Y. Both X and Y are respondent. Possibly with that view, they want a continuity.
please.
Appellant and then,
That,
why don't forget, don't look at the pages.
yes.
That's not the, should be the relevant consideration.
But,
There should not be any confusion later.
yes. My primary submission, my lord, is it's as per the format prescribed in the proceedings rules. What I have submitted.
That interpretation may be the manner in which you did.
Yes, my lord.
Avoid confusion at a later stage. Better would be there should be a continuity.
Please,
right?
my lord. I,
Who is the appellant? X is the appellant. How many respondents? 75 respondents. 1, 2, 3, 4. Their status is known.
please.
So-
I'm in your lordship's
Do
hands,
that.
please.
Okay. Then a counsel for the appellant seeks a week's time to remove the objections as notified by the registry.
I'm grateful.
2 weeks.
Please. May I request for a date, my lord, subject to your lordship?
Yeah, we'll give you date.
29, sir.
I'm grateful.
Serial number 10, Sharon.
I appear for the respondents in the matter.
I'm
my lord.
appearing for the petitioner in this matter, my lord.
But
The
the last
matter is listed
occasion-
for mediation. I apologize, ma'am, you can submit.
This dispute between the parents of the minor children, the matters sent for mediation. Along with this, my lord, there are 2 cases which I filed, one filed by the father in the GNWC and one filed by the mother, also pending the family court miscellaneous petition. All these matters are pending mediation before the mediator. So the await notice is, that is where it is mentioned, my lord. So far as non-filing of the memo, my lord, on that day itself, memo has been filed. We have also paid the school fees. I am placing on record the memo in that regard, my lord.
What happened in the mediation?
Mediation, my lord, the children, there was earlier order by the consent, there was a divorce petition, my lord, in that there was an arrangement. And thereafter now, my lord, certain changes are required and therefore, and as she had agreed to shift the children to Chennai, the children were admitted in Chennai. But however, she filed, this case was filed in habeas corpus, children are with her now, pursuant to directions of this honorable court. The mediation is going on to explore the possibility of amicable resolution on all issues. And Monday, we had one session with the father. The other session may be tomorrow or whatever date is convenient. I'm not aware what date is listed unless the other side.
We will defer this procedure.
It is listed tomorrow. It is listed tomorrow, my lord, for
Lordship may-
mediation.
Work it out before the mediation.
Please, madam.
At the joint request of counsel for the parties, re-notify.
I'll file this memo in the office.
Request of counsel for the parties for an adjournment on the ground that the mediation process is still in progress, re-notify.
13-8. 11.
May Lord kindly grant me 2 weeks' time to remove the objection.
Let notice be issued subject to the appellant petitioner depositing the process fee. Issue notice to respondent number 2. Returnable on.
25-10.
Thank you, Lord.
Serial number 12. Pichelu Raju.
Petition, Your Lordship. Matter is pertaining to inter se seniority in the railways, please, my Lord. The office is raised
You are
certain.
ready?
Lordship,
Are you ready?
yes, Lordship,
Argue.
I am ready to argue. this.
My lords, I see for a pass over, my lords.
I will pass over.
Please.
Call the council.
13. Shrikant Patil.
For the appellant's counsel, let's, it was indicated that we should file a synopsis and the matter will be taken up. Let's, I'm only, the synopsis are ready. I'll file it today. Lordship may kindly have it on some other day. In the connected matter, the notice is yet to be returned, my lords, on the LRs. It's 13.1. Awaiting service of notice, but
Who has died in 13.1?
R6, respondent number 6 in the connected matter. Which?
R6, sir.
Respondent 6. Who has filed this application? You have filed it?
The appellant has filed
Appellant.
to bring connected matter. Yeah,
We issue notice on the proposed
it
respondent.
has already been issued. Notice is, my lords, the service report is awaited.
What is the service report, ma'am? Oh, it's not, it's still incomplete.
It has to be, we have to await this service.
Just say this, but is this respondent not in the other writ appeal, 1405?
He is not there in the connect, in serial number 13, he is not there.
You can otherwise just say this, counsel for the petition, appellant submits that the synopsis shall be filed during.
My lords, it's there. If your lordship permits, we'll file it across or in the register.
Yes, just give it to us.
Please. In 1405 of 23.
As filed in the court written synopsis with a copy to the learned counsel for the official respondents, the same is taken on record. We find that the notice to LR to respondent number 6 in terms of IA
2 to 4.
2 to 4 minutes. 2 to 4.
of 2024.
Idu ideyallappa R8 ಬೇರೆ.
234 of 24 is still incomplete. Let fresh notice be issued to the proposed LRs of respondent number 6, returnable on.
It's a notice. We have to await notice, my lords. Notice is already issued.
But we have to fresh issue notice, na? But that's incomplete. Returnable.
Allah, report has not yet come back.
That's right.
Very well, my lords.
The notice is for today.
So far.
Very well.
Okay, so far, 1 it is, I shall be filing synopsis for it in the office. The connected appeal.
See now, maintainability, what is the for hearing on maintainability?
My lords, that the opposite side has filed, whether we have the locus to file a writ appeal. That's why, my lords,
Not party before the learned single judge.
we were. But still, my lords, the opposite contesting parties.
We will see at that. Now, what about the steps taken to a deceased for the
R8.
counter? Who has filed the counter affidavit? This is on
Condonation of delay that, my lords, for that the contesting respondent has filed its.
R5, R7, 9 to 12. You have any objection on this?
Lords, no, they have filed counter because I represent the appellant for the condonation of delay.
That's right, for filing counter affidavit.
Lords, we have, because they have filed their counter affidavit to our IA for condonation of delay.
Oh, you are IA for.
For condonation of delay, they have filed their affidavit, counter, my lords.
Okay, then we will retain it. Very well. Then let date be given on those applications.
23/9, sir.
What about 13.2?
13.2.
13.2.
Is R6 here? No.
Aurilla, 13.2. I don't think that.
No, the
party-
R6 is not, there is no such application. Yes. So,
Can we, one request, can we make a shorter date? Can we expect?
pardon?
Can we expect a shorter date than?
We are given you date in September. What is the date, ma'am?
The 23/9, sir.
23/9.
Not mistake. Put there before.
Just advance it.
Subject to lordships.
17/9, sir.
Next.
Very, very.
Serial number 40.
Lords, it may be on
See, the
23.
notice has to be served
Very.
on the LR.
My lords, let it be on 23 because 15 to 21st, I am not in the country. So let it be on 23rd, my lords.
Very well, whatever you say, just
3/9. sir.
23,
23/9.
please.
14, Srimati Renuka.
Next.
Will it appear for the appellant?
Yes, ma'am.
The respondent,
Yes.
my lord, was a conductor.
Yes, ma'am. See, maybe something can be said on the impugned order. But the fact remains,
Continuation and the court. Serial number
right,
13.
what do you say?
Road collection.
But he has reduced it to 5 increments, no? In the past also. What do you say? See, let's be very clear.
My lord,
Huh?
those cases are not referred, my lord, either in the inquiry or before the labor court tribunal, my lord, or in the, at least in the.
Do you
subclass notice.
contest that fact?
My lord?
Do you disagree?
Yes, my lord, disagree, my lord.
Are you sure?
Yes, my lord, disagree, and also management failed to produce and failed
He will
to.
not take that. You disagree, you say that 97, it is not
Yes, my lord, yes,
97.
I am disagree, my lord.
How many are there? Tell us. Not 97, 47, 50, 75?
My lord, 1 or 2 minor cases were NINC cases, my lord, you imposed a fine of rupees 100, 200 rupees, my lord. No serious cases in my entire service.
But what about this?
Even, my
1,000
lord,
rupees?
my lord, one submission. Even, my lord, after reinstatement pursuant to the order passed by the Samal Court, my lord, from 2017, my lord, even till today, my lord, I am not committed any misconduct, my lord, even till today, my lord.
See, that's not the test. Test is, insofar as this 1080 is concerned,
Not
Those-
1080, my lord, 108, my lord. 108, my lord.
1080.
108, my lord.
Are you sure, ma'am? Is it 1080 or 108?
108, my lord.
But the figure, how many passengers? There were 26 passengers.
Well, 108 rupees, my lord, not 1,080.
How do we get that? Is it 108? All right, then 5 increments, man. See, 108, although even 1 rupee is sufficient. Those 97 cases. Show us. Yes. These are all punishments. How many years of service he has put in? How many years of service?
11 years as on the date of dismissal. 11 years as on the date of dismissal. 2006.
Is he entitled to pensionary benefits? Will be entitled to pensionary benefits? No, on the basis of the learner single judge order. No, he gets reinstatement. No? Then it would be continuity of service till date. Has he retired? Has he attained the age of superannuation?
No.
78. What is the retirement age? So 22, 24, 46. Around 46 years. He still has service. It's not pensionary benefits. 78, 22 there and 24 here, 46. Then I think, ma'am, 5 increments is fine. No, you're right. That possibility. You are right. Where is the judgment of the Supreme Court? Tell us one thing, in view of the Supreme Court position law, how can this observation be there by the learner single judge? Just see this page 18. In my considered opinion, it is not sustainable in as well loss which has been alleged to have been caused to the corporation is a sum of rupees which would not, in my considerable opinion, require dismissal.
108 rupees.
Let's assume 108. The
Right.
Supreme Court has
Not-
upheld even 16 rupees.
This is a case of non-issue and not collected the fare, my lord. Non-issue, non-collected. And the reason is, my lord, even before.
Tell us one thing. If you have issued tickets, you will collect the money. If you have collected the money, not issued a ticket, there is an.
My here, my lord,
If you have not collected money nor issued the ticket, then also it is a misconduct.
yes, my lord.
So to say that 108 is not a misconduct which will entail dismissal, possibly we have a reservation.
In his entire service, my lord, this is the first red mark case in his entire service, my lord. This is the first red mark case. There is a classification for cases, my lord, minor case, red mark case, and outstanding red mark cases. In minor cases, my lord, they imposed fine.
Where is the judgment, man? The Supreme Court says otherwise. This is going on the face of a. the labor court found fair and proper,
Yes, ma'am.
then it could not have gone. Then it could not have, proportionality is only when it really, it really, in a way, is so disproportionate that it could not have been given.
Labor court suitably punished the workman, my lord, by reduction 5 increments with cumulative effect, denied entire service benefits, my lord.
It's difficult.
My lord,
It's like this shocking the conscience of the court. Then only you will interfere. Let's assume as against this charge, there is a charge of unauthorized absence. And he says they were the gravest of they were compelling reasons for him to remain unauthorized absence, like mother's illness, wife's illness. He said, I could not have done anything. In that case, if they have imposed a dismissal only for 10, 20 or 40 or 1 month or 2 months, surely. But not in a case where it's like saying loss of confidence.
my lord, your lordship may kindly appreciate the, my lord, a subsequent conduct of the workman also, my lord, even till 2007, my lord, he did not commit any misconduct, my lord.
Is that a consideration? That does a person employee has that you can commit 10 misconduct, but I will not take any action. That is not a yardstick.
But my lord, Supreme Court says that, my lord, my lord is reinstated, my lord, that portion is not disturbed by the Honorable Supreme Court, my lord. Lordship. My lord, para 5, my lord. Para 5, my lord. It is pertinent to note that the ticket examiner was examined in the inquiry and he deposed that 8 passengers.
These are in this circumstances, Supreme Court has said, minded. This held, it shows respondents were responsible for that. In this, labor court was not justified in holding the punishment was shockingly disproportionate. Over respondent having been reinstated.
Reinstatement that has not been disturbed, my lord. In my case, my lord, I was working since from 2017, my lord, without any bad remarks, my lord. That may kindly be considered.
But how would you answer this? So many. How would you answer this? Was this part of the labor code? You exhibit.
First time,
94,
madam, my lord, first time
92nd.
produced before the labor court, my lord. The same was not confronted at any point of time, my lord.
Won. What is REC rupees? Received rupees. Disposed of, punishment. Or recovery.
No such increment has been withheld, my lord. Only fine was imposed, my lord, some occasion, my lord.
You have a look.
Yes, my lord, I saw them.
There are
Because
97, there are
they produced
97.
before the labor court, my lord. But the same was not brought to the notice of the workman before passing the order of dismissal. In Manchagoda's case, my lord, the 3-judge bench held that, my lord, the alleged history, my lord, has to be confronted at the time of issuance of article of charge at the time of issuance of so-cause notice. My lord, first time, my lord, the same was produced in the labor court, my lord. That is also not established by the corporation, my lord.
It's a part of exhibit.
No, that is separately produced before the labor court, my lord, after workman raising the dispute, my lord.
Tell us one thing, the labor court could have also called for the evidence. It could have. Otherwise, it could have asked the employer to prove the charges before it. It could have done. The labor court in exercise under 11A or 2A can ask the employer to prove the charges before it. It could have done it.
No, my lord.
Why?
No, my lord. Just produce the history sheet and did not led any evidence on that point.
Tell us one thing, will it be possible to compulsory retire him on that day? Whatever it's worth. So he's not there. Oh. No, as a punishment. Penalty. So it's not there. Then difficult.
My lord, the annexure E, the deposition of management evidence before the labor court, madam. Page 80, madam. Cross-examination 85 translation, madam. Last paragraph, madam, 85, last paragraph. Print of exhibit M4 has been taken on 11/2/2017. Well, you were dismissed from service in the year 2016, madam. Therefore, the offence mentioned in the history sheet has not been mentioned in the charge sheet. Exhibit M4 has not been produced before the inquiry officer.
Which is this exhibit?
That one, history sheet, madam. History sheet, madam.
No, it's exhibited as exhibit R4.
The same, madam. I am for R4.
It is not mentioned in charge sheet.
Yes.
Even she accepts.
Charge sheet I will continue. There is no mention about exhibit M4 in the Sokas notice.
See, we will not accept it. Let's be very
Yes,
clear.
yes.
You don't deny it. But this history was there before the labor court. Whatever it's worth.
Yes.
You don't deny it. And it's not one or two instances. There are 97 instances.
Well, all the cases are petty cases, my lord. There is a circular issued by the corporation. I have produced the circular, my lord. The corporation go on imposing fine, my lord, for case of one NINC or NIAC, whatever it may be, my lord. They are imposing fine to take into some circumstances
What
in which.
reasons? For what reasons?
My lord, they themselves issued a circular, my lord. For first, in case of minor case, my lord, impose a fine of rupees 100, 200, 300. But there is no limit fixed, my lord, in the circular, my lord.
Right, but that is only because you have taken money and not issued tickets. And they sought recovery.
Well, in all the cases, NINC or NIAC, non-issue, not collection, or not issued, not after collection.
Right, obviously.
In all the cases, they imposed a fine of rupees, the 100, 50 rupees. They will also kindly see the.
But there is a reason.
No serious trademark case in my entire service, man. Like NIAC, amount collected, not issued tickets. I never done at any point of time in my entire service, in NIAC cases. These are all NINC cases,
These
happens.
These are all which cases?
NINC cases,
What do you mean by that?
Non-issue, non-collection, It happens, my lord.
Non-issue, non-collection is you are allowing to.
No, it happens, my lord, due to rush of while he was duty and passenger lost the ticket, they have to pay the fine. In such circumstances, they are treated as NINC, non-issue, non-collection. And some passengers over travel, they collected fine and issued an offense memo saying that non-issue, non-collection. That's the reason, my lord, the corporation liberally.
Supreme Court said rupees 16.
Normally, in the present circumstances of the case, there is no serious trademark case in his entire service, my lord. Before and after, my lord. My lord, labor court, my lord.
Figure.
My lord, even before the honorable single judge, my lord, the management himself extract the work, my lord. Instead of paying 17 wages, my lord, they extract the work since from 2017, my lord. Now he's working, my lord.
He's working.
Working, my lord.
Is he working?
Yes, my lord. 2007, my lord.
One minute. By passed by this court.
Yes,
Then ma'am, then tell us this order would come for his aid.
yes.
You should have said, I'll pay 17B, let him be outside. So then your plea of loss of confidence will not sustain. Right? What? You are right. But with this also background, you have still taken him. And when is he working from?
2017.
Ma'am, we were with you if he was not been taken on rolls. And since when he has been working?
2017.
Oh, 7 years down the line, then I don't think we shouldn't. See what is your apprehension? This gentleman will come back. It's a case of loss of confidence. That's your case. For 7 years he is working. Is there any misdemeanor thereafter? Then I think we'll put quietus. Now we will. That we will say. That we will say. So we will record your statement that is contrary to what has been held by the Supreme Court. But we will say so in view of the fact that he has been reinstated. Then ma'am, no.
There are instances where they are not given their license from service and be placed before the court, such cases. But what happens, that cannot be held in this corporation,
On a principle, you are taking a stand, whatever it's worth, even if you had to pay 17B, you will take that stand. You say, we don't want him because of loss of confidence. That's not the case. 17, he has been working for the last 7 years. You should have sought the disposal of the appeal. It's all right. That we don't say anything on you. Surely we will not say anything on you. But the fact remains first. We will record it. We'll record it even after 17. There is no misdemeanor. Is there any further charge sheet?
No, madam. No, madam.
No, we will say this. We will not say misdemeanor. We will say no charge sheet after 2017. We will record his submission. We will say so insofar as that observation of the learned single judge is contrary to the judgment of the Supreme Court. And minded this judgment of the Supreme Court exactly on facts, identical facts. No, it's like this, ma'am. We have to read in perspective. No entitled to no back wages, but he is entitled to continuity of service and all other consequential benefits. He may claim possibly promotion also when there is a continuity of service.
but that's the reason we're not agree with your loss. In the back.
We got it. For all purposes, when they say no back wages,
Yes, ma'am.
will that include the leave encashment?
No, my lord.
It would not.
No, I'm not claiming any leave encashment during that period, my lord.
So we'll say not entitled to back wages.
Not entitled for any leave benefits.
But very interestingly, you see that not entitled, even seniority is not entitled to, but
Yeah.
that's something we can't agree. How can not be given seniority when he says continuity of service?
Probably about for 1 year, it's not also 2016 to 17.
So we'll clarify it. Continuity of service, which shall include seniority. We'll say so, back wages, without no back wages of any kind. Of any kind, but with continuity of service. That's all we'll say.
Leave to your lordship.
That's all.
Leave to your lordship.
Pardon?
Leave to your lordship, my lord.
The challenge in this appeal is to an order dated when 10th January 2023, passed by the then a single judge. Why there were two petitions?
Workman also filed question there.
In writ petition number 56249 2017 and 58344 of 2021, whereby the learned single judge has disposed of both the petitions by stating in paragraph 9 as under. As to the submission of learned counsel for the appellant is that the observation made by the learned single judge that that the loss which has been alleged to have been caused to the corporation is a sum of rupees 1080. Just say that, wrongly mentioned. Just say in the bracket, wrongly mentioned as such. Otherwise, the figure is 108, bracket close. Which in his considered view would not require dismissal of the respondent from service. According to her, this observation of the learned single judge is contrary to the law laid down by the Supreme Court in the case of Depot Manager Andhra Pradesh State Road Transport Corporation versus V.V. Rao 2007 15 SCC 675, and also in the case of Regional Manager UPSRTC Itawa and others versus Oti Lal and another 2003 3 SCC 605. Full stop. She also submits that apart even the past background, even the past service record of the respondent would reveal that on 97 earlier instances, the appellant had imposed penalty, including recovery of the amount. Full stop. We have seen the judgment of the learned single judge and also heard the learned counsel for the parties. The paragraph, the admitted position is that the respondents has been reinstated in service in the year 2017. Full stop. According to the learned counsel for the respondent, he has since been working as conductor without any blemish. Full stop. In that sense, he states that the order of the learned single judge is justified. Full stop. Full stop. He also states
Driver cum conductor. Driver cum conductor.
Driver cum conductor. He also states that the 97 instances on which appellants is relying upon is an incorrect figure, or even otherwise. The said factum was not subject matter of a charge sheet which was issued to the respondent, and hence could not have been relied upon by the appellants against the respondent. Full stop. The learner counsel for the respondent, appellant would dispute this submission made by the learner counsel for the respondent. Full stop. According to her, the 97 instances were placed before the labor court by way of a statement, and the same was exhibited as MW R/4, R4, exhibit R4, just say exhibit R4. And hence the said factum having been proved, comma, the same cannot be disowned by the respondent. Full stop. The learner counsel for the appellant has relied upon the judgment in the case of regional manager UPSC, Itawa and others, Supra, to contend that even 16 rupee, even where there is a loss, where there is a loss to the exchequer of rupees 16, comma, the same was held to be, resulting in dismissal, the same was held to be valid. Full stop. She also states the judgment relied upon by the learner counsel for the respondent was in the facts of that case and cannot be read as a cannot be read to be as a precedent. We are unable to agree with the submission made by the appellants. No doubt it is true that the observation made by the learned single judge, which we have referred to above, could not have been made in the fact in view of the judgments relied upon by the counsel for the parties. But the fact remains that in lieu of paying wages under section 17B of the Industrial Disputes Act, the respondents, the appellants have reinstated the respondent. Full stop. And there is nothing has been placed on record to contend that even after 2017, the respondent was involved in identical misdemeanor. Full stop. In other words, the record post 2017 being clean, and the respondents has been working in the appellant corporation for the last 7 years without any blemish, keeping in view the dicta of the Supreme Court in the case of Depot Manager, Andhra Pradesh State Road Transport Corporation. More so when the Labor Court has also, when the learner single judge has modified the and the Labor Court has modified the penalty to reduction of 5 yearly increments with cumulative effect, the same shall meet the end of justice. Having said so, we are of the view that the final observation of the learned Labor Court as upheld by the learned single judge has upheld the 5 years. We are of the view that the petitioner shall not, the respondent shall not be entitled to back wages and back wages of every kind, including the leave encashment, for the period during which he remained out of service. Full stop. But he shall be entitled to the benefit of continuity of service, which shall also include seniority. Okay, with the aforesaid observation, no, we have said so. Fine, we are not interfering. We are not interfering. That penalty would remain. Now you have to possibly operate that penalty. We don't know after his reinstatement, have you operated that? Operated? Are you sure?
Probably they will treat the government not as a single employee. So his pay will not have been
fixed. You will only say that in lieu of 17B, I am calling him and I will pay whatever he was being drawn, he is entitled to under 17B. So the appeal is disposed of. Take this, ma'am, just give this back to them.
15, Shri Ravi Shankar.
Yes.
Yes. The petitioners are also. They are working on the report. Say that these lands belong to us. There are no 6.30 acres that are left there. They are trampling on our rights. And the Arbitration made a submission, which was recorded with the first day itself. The last day that which para 3, which may be permitted to read. Has today made a memo along the service station of the share. The total case and adding 188. Another entity point out with service station shows the new service assigned to the land surrounding the various persons, including the petition. He submits that the green color portion marked in the service station shows 6 acres there to us of time survey, which is now sought to be a mark for the color of our shares. Subject that no portion of the land is already granted to various persons, including the petitioner. He is said to be utilized for the said purpose. In that way, the court finds that the petitioners have rushed to court without ascertaining the proper facts. Petitioners may be less assured that in terms of the survey sketch produced by the reviewer, along with the memo dated 24/23, only such portion of the government land which remains without being granted to any other person is being utilized for an expense for the purpose. This would be observation that despite this particular observation, I have approaches on the was in the block of not touching my property and there is a separate year marking of 6 acres that is done. It's not family on my rights and my property. Only like that. This court observed a detailed order is passed with some court. After I demonstrated before this court, there are multiple sketches that are used by the revenue authorities themselves. One showing that my land belongs here, another showing somewhere else. Therefore, I made a submission that multiple sketches would clearly a detailed order is passed with this from the board. I may be permitted. My notes are this was order dated 21/7/23. Then read this 2 pages order. Heard zones. On perusal of the material based and report, it reveals that there are 3 stages. First stage is at page 235, document page 234 is a summary letter dated 23/23. And the contents of this document indicate that this particular stage appears to have been drawn on 23/20. However, there is no reference to the date in the said stage. Then there is another stage based on record with appellants by way of application filed with sworn on 27/6/23, which is annexed at page 258. Perusal of the said stage show that there is marked difference in the first stage and the second stage. There is no reference to the date in the said stage. Then the appellant is placed on record third stage at 261 at annexation 1. Again, there is no reference to the date stage is drawn. This third stage differs from the earlier 2 stages. This being the factualization, responding government authorities are called upon to explain the way to respond to 4th Ashina as to which one of these sketches is authentic and reliable. We further call upon the state government to respond to 4 to specifically state the action area that is demarcated for RTR scheme. We may also state that in view of the submissions made for the learned single judge with additional government, an observation was recorded by the learned single judge paragraph 4 that no portion of the property belonging to the petitioners will be utilized by the revenue authority for the said purpose. The appellants have raised a specific contention that the action authority of the revenue department is contrary to the statement made before the learned single judge, as much as without specifically demarcating the area purportedly reserved for RTR scheme. They are interfering in the possession and enjoyment of the administration. That they have even erected certain boards to the property of the administration. In view of the opposite factual aspect, and in view of the apprehension interest in the administration, we have considered due to the justified apprehension in mind that the authorities of the state government are in the process of executing the disturbing possession, as said the law to be filed in remarks. Despite this there are two submissions with this matter. First submission, this honorable court has laid upon the apex court and said that the partial scheme is unconstitutional. This is the judgment that I have. This earlier. So the scheme itself, we have implemented the scheme at all.
No, but that's besides Mr. Ravi Shankar. But these your lands have been utilized for this scheme.
No, madam.
No, have they filed that affidavit?
We have filed an affidavit, madam. 15/12/23 we have filed.
Regardless the degree model that I will. They are still there giving them any more to the work. They are already, the orders passed with this.
But there is a status quo order.
There was a status quo order. They were not supposed to do it. It was a barren land. It was an apprehension. Despite this court's order, they have trampled upon my rights, trampled upon my property. They have not court.
But have they changed the status quo?
They are in the process of changing. Because
No,
they are
they-
giving,
They are in the process means what?
they have given work order to certain people to carry out.
But have they done it physically doing it?
Because of the rains and the things there.
Okay, but the status quo remains as it is.
Despite the order of the status quo, they have utilized the property by giving, they have outsourced the excavation work and all that. I have dug up the place, I have produced documents and also website documents indicating. Given their contractor to carry those reports.
What are your instructions?
My lord, as per affidavit, it reveals they are not, properties are not belong to the plaintiff, the petitioner here in my lord. The work is which is going on.
No, but there is a status quo order here.
Yes, my lord. We are not doing anything, my lord. The thing is, my lord, I have to receive instructions because the affidavit was filed saying that the property of the petitioners was not utilized for this purpose, my lord, because the remaining extent of land remains with the government is 40 acres, 2 guntas, my lord.
What is being said here in this? Please get to the. Now tell us one thing, these three sketches includes your property also? All the, but how much your land?
6 people, 2 acres each, we were granted.
No, does this, your land falls in all the three sketches?
Because on my land, they are indicating this, they are out of the 6 acres that we put down. On my land. That's my case.
That 6 acres is being used for this scheme.
Partial scheme. So they are coming to me, my land, taking away my land, and saying that we do this scheme of God. They made a submission before the budget single date that my rights will not be trampled. They will not touch upon my land. They admitted my ownership.
But tell us one thing, Mr. Ravi Shankar, now, okay, but that you may say that on ground, the position is different. Though they made a statement, actually, in fact, they are now utilizing it. What does their affidavit say?
There says that the land is elsewhere in the same location. The land is not where I am saying. That's their.
No. Do they say that the land with which they are doing it is not your land? The land on which they are carrying out this scheme is not your land.
That's what they are saying.
They are saying so.
That's what they are saying.
Now, how would you answer that?
It's false because the sketch that they rely upon of late along with this affidavit is the same sketch that I have produced at an earlier point in time. This court already has, and a prima facie level stated that 3 sketches are placed before the court. One, not similar to the other. They are different sketches with the same authority at different points in time. Principally,
You say that is your land, they say that is not your land.
Second submission. They cannot carry out this scheme account. This court will bring
No,
it
my
to
lord.
state.
But to be, if it is not your land, you are not
I'm
concerned.
not.
You are not concerned.
Because I want like 2 acres, these 6 feet.
That's all.
That's all.
Whatever they do, whatever the landowners do, that's their problem.
No, they will be trying to somebody else's land, they will have ours.
Right there.
They will have it. Sufficient, sufficient.
These are the photograph which you have filed,
Yes, but I have produced, yes.
but there is no activity going on.
Along with the allegations that I filed on 8th February 24.
Yes.
I've been able to, the trenches have been made. And they have used me, I also a villager standing in front of it.
Now, what was the nature of affidavit they were to file?
They have filed. They were supposed to say, explain, they're actually not explaining at all, this court wanted them to explain as to the reason how they drew three sketches, one different from the other. This court wanted them to explain. And there was no day, they were different in character. So this court wanted them to explain, which they never explained.
Have they explained which is the actual area demarcated for the scheme?
They have not. What they have stated is like this.
Have you filed the affidavit in terms of this?
Malad, para 6 Malad, para 6 Malad, in the affidavit Malad, para 6 Malad. Affidavit filed on 15/12/2023 Malad. How do you?
I also got the report from the review inspector with regard to these cases. The said review inspector conducted this part, which is submitted the report on 17th and 22nd. After this is produced with the annexure after.
Mr. Ravi Shankar, did you file any response to this affidavit? Now, how do you say so? See, there is a very positive statement made that no connection with the lands of the appellants.
Yes, Malad.
How do you say?
Because the sixth day, they have found the annexure. So when we see page 235, which is the original text that I have here. That was page 7 in the response.
Page?
235 in the interview. And in page 7.
235.
Which is on supported record in the appeal form.
Yes.
It's the same.
Which is your land? Which is your land? And where is their sketch? That's right, 7. Where is your land?
My land is in page 235.
It is the same document at page 7.
Yes, sir.
No,
Same. One that they are showing in Australia sketch, Australia scheme, is the same. My land is here.
Star was.
no, but, okay, that's the cross.
The cross.
Okay, why do they say cross?
They wanted to say that this is carved out as 6 acres 34 lots for the scheme. That's why they
The cross is the cross is for the scheme.
The bottom,
The cross, what does it say?
it says that 6 acres 34 lots is carved out of from this larger extent.
ಆಶ್ರಯ ಯೋಜನೆಗೆ ಮಂಜೂರಾದ ಪ್ರದೇಶವಾಗಿದೆ ಕಡತದಲ್ಲಿ ಲಗತ್ತಿಸಿದೆ. This says 6 acres.
Which is their land according to your sketch, page 7? But they can tell us which is your land.
In this entire extent was government land, my lord. After grant, the coded and assigned a new survey numbers below which was shown, my lord. Remaining extent which was there in the government name.
The 235 which you have read, his sketch,
Yes, ma'am.
along with the writ appeal,
Yes, ma'am.
that cross says what? What does this cross say?
That is demarcated for the purpose of Ashraya scheme, my lord.
Okay, that's Australia scheme.
Ashraya scheme land, my lord.
Now,
The
this-
below
this-
the numbers was mentioned, my lord. Below the numbers was mentioned, which was coded and assigned a new survey numbers. In that sketch, my lord, below the boxes was there, numbers was shown, which was,
This cross which you have put is his land?
no, my lord, it's not
his-
belongs to him.
Oh.
After allotment, 40 acres
How
was
would you-
remains
how
with the
would you-
government.
How would you identify his land? And tell us what has you filed to say that this is my land, this is the position of my land? How would you RTC reveal that the location of your land on the surface, on the ground?
RTC won't reveal. RTC won't
They
reveal,
will
my
not.
lord.
So, sitting.
They have appealed because the others will, para four, para five.
We have not disturbed.
They're not
We are
understanding.
not on the, we are on that.
Ravi,
word.
just one. Let's assume this place. Let's assume that place.
Exactly.
Exactly. You have a land, they say we are not touching his land. But where is that land? That's the point. Where is that land?
Ultimately, one, they all. Very difficult to get.
No, but how do you identify a land? Are you as a council convinced that this is the land? Then we can take it further.
Saying that they will not ban the county and they will not touch me.
Right? That's right. To that extent, it helps you. But the fact remains that statement,
Exactly.
the statement become purposeful.
They have to identify, the commissioner.
Hmm.
They have to identify. The second point also.
My lord, in that 235, my lord, page number 235, my lord. On the top, the numbers was mentioned, my lord.
152.
235, 152 survey number, my lord. After assignment of a POD, the new numbers will be given, my lord. New numbers will be given. Sketch was prepared by placing that new numbers, my lord. 225 is there, my lord. 226 is also there.
Even the survey number gets changed.
Yes, my lord, it has been changed. 152 is the old survey number which was retained by the government.
Got it.
After allotment, it was assigned a new survey numbers. New survey numbers was given to them.
The same, number 152 was the original survey. What emanated extends from that is the fragments case. So 152 was the original.
But will that mean 152 by 1, 2, 3, 4, 5?
Sometimes they do that, sometimes they give a new number.
P number will be given, my lord. P number will be given. After
25.
40, new numbers will be given. My lord.
But it says 225, if you say 80.
At the top of it, 225 is there.
Page 80.
RTC 82, page 82, 82. MS Lalithu. Govinda Nayak.
The name is there.
Yes.
Govinda Nayak. Now it's 225. If you see the left-hand corner, where is 225?
At the sketch top, it is there. At the sketch, my lord, 235.
Now show from your survey.
235, kindly see the 235, page number 235, my lord. This entire extent is 152, my lord.
Yes, ma'am.
Entire extent is 152 survey number, my lord.
All has-
After granted, it was ported and subdivided into sub numbers, my lord. As per that, kindly see the top of it, my lord, on the right hand side, 225, which was written, my lord.
Yes.
That has been demarcated, 225 belongs to him, my lord. We are not going for that.
Where is
6
225?
my lord,
Where is 225?
on the,
No, that is there on the surface. Where is 225?
as per sketch, it is there, my lord.
Where is the sketch? Your sketch. Let's see page
235, my lord. Kindly see the 235, my lord. Page number 235. 235, my lord.
Ah, 235.
Yes, my lord. On the top, my lord.
Top is 152.
No, my lord, 225, it is written in Kannada, my lord. ಎಡಗಡೆಗಿದೆ ಸುಮ್ಮನೆ ಎರಡನೇದು 225 225 ಅಂತ ಇದೆ ಸುಮ್ಮನೆ.
You say page 235, no?
Yes, my lord. Page 230. Sketch was which?
Sketch
Sketch.
is
Yes,
there.
my lord.
Identify it. He say that is your land. That's right. His
Yes,
land.
my lord. That's only his land, my lord. As per sketch, remaining extent remains with the government, my lord. Yes, my lord.
That's your land. Now they have identified your land as this. How much is the area?
2 acres.
2 acres.
2 acres.
No, one is 225.
Yes, my lord.
Which are the others?
Other survey numbers are
Where is 175? Page 49. Does that, is that been demarcated? No, don't go by RTC. If there is a sketch which can be identified. No, but right.
as per possession only, the demarcation was taken place, my lord. As per their possession only, demarcation was taken place. Podi was conducted. As per Podi, the assignment of new numbers has been taken place.
But based on RTC, there would be an identification on the surface.
So that is.
Where is 235 survey number? One fifty, 152. Where is 152? In that page 235. One five two. 152, where is it? Now this scheme is this scheme is being operated at survey number 152.
Yes, my lord, 150.
Where is 150?
After Kodi, the remaining extent is 152 million.
Right, so the the scheme is at 152.
Yes, my lord.
Nowhere
150
else?
152 million.
Nowhere else?
Nowhere else, my lord.
Where is that?
Sketch it has been demarcated, my lord. Star was put 152 star. It says 6 acres, 30 guntas for Ashraya scheme.
Just give it to him. 152.
I'll get entire Podi, my lord, in respect of this survey number, my lord. Entire Podi and how the demarcation was done. One 152. One 152.
Yes.
150.
It is 150.
Other 150.
Oh. Right,
Body-
it's quite
body-
near to your land. Yours is 225. Adjoining. Now they have identified it. We can do one thing, we can ask them to file an affidavit identifying the 152 as the survey number where the scheme is being operated. Okay, which excludes your land. And that affidavit will file and we will take the chart on record.
Yes.
So that means that gets identified. What is there is this. Mr. Ravi Shankar, simple. Are they touching your land with the scheme?
Yes, sir. That's the point. That one is.
No.
In the crop of doing some.
See, that's the reason we are saying, if he files an affidavit, maybe coloring the portion where the scheme is being carried out. Okay. As against your portion by a different color. Let them file it and we will take it on record. That puts
There will be some progress.
progress, at least you would be clear. And they are clear that that is your land, we are not touching, and you would be clear that is the other land where they are following the scheme.
Yes, ma'am.
We have heard the learned counsel for the parties, Mr. Ravi Shankar, learned counsel for the appellant has drawn our attention to the order passed by this court on 21/7/2023. Full stop. According to Mr. Ravi Shankar, pursuant to the aforesaid order, the respondents have filed an affidavit. The paragraph
6 and 7.
6 and 7 reads as under. Full stop. Full stop. It is the stand of the respondents that it reads as under, this would be affidavit filed on 15/12/2023. 6 and 7. The stand of the respondents in this said affidavit is there is no encroachment in the land allocated for the Ashraya scheme or the land belonging to the appellant. The learned counsel for the respondents would state that he will file an affidavit along with the sketch identifying the land which is being used for Ashraya scheme as against the land of the appellants by two different colors.
Yes.
Okay.
Yes, madam.
According to him, once the land of the appellants gets identified, the appellants can be assured that their land is not being it has not been encroached nor being used for Ashraya scheme. Okay.
Yes.
So the affidavit in view of the submission made by the learned counsel for the respondents, the affidavit shall be filed within how much time?
3 weeks, madam.
3 weeks, full stop, call after 3 weeks. Once that is there, you take it on because it gets identified.
30th August.
That's how you do it. Next one.
Other. Unnumbered entire extent is 250 million. Unnumbered entire extent is 250 million. Demarcation was made subject to their body was occurred.
So you will identify it.
Yes, madam. We'll do it, madam. Unnumbered entire extent was 250,
Yes.
40 acres.
Let's see
40
this.
acres was granted, 40 acres was remaining with the government.
16, serial number 16.
Lord, I undertake to appear for respondent, not the sir. Pradeep Sankar.
Who is for the appellant?
Narasimha Swamy.
But I'll tell us one thing, why only left with one person? One person left?
No, my lord, there are several others, my lord. But then the factory now is closed. Activity now, my lord, in Bangalore, my lord, manufacturing activity has been closed. And my lord, this is an application under 33(2)(b). Now, my lord, your lordships are aware, the jurisdiction under 33(2)(b) is limited. Now, my lord.
But any finding on victimization?
Yes.
Yes. There is.
There is no pleading also. There is no pleading regarding victimization. And my lord, the learned Singh, the tribunal proceeds to hold that the punishment is disproportionate. Now, my lord, all those issues do not come under 33(2)(b). 33 is a limited jurisdiction. The moment, my lord, the inquiry is found to be fair and proper, and there is some material to hold that the finding of the inquiry officer is just and proper, my lord, the question of interference would not arise.
And additionally, possibly victimization.
Yes. No, my lord, victimization, my lords are aware that the way back in 62, in Hamdard Davakhana case, and later on, my lord, in 1976, in Bhagubhai Patel's case, my lord, Bharat and Barks, the Supreme Court says, my lord, victimization, plea of victimization is a very serious charge. It has to be properly pleaded and proved. Now, my lord, the other aspect is, once the court finds that the charge is proved, now, my lord, the question of plea of victimization pales into insignificance because proof of misconduct is antithesis to the plea of victimization.
But tell us one thing, charges may be proved based on, suppose if the regional opportunity is denied, will it not be a case of victimization?
No, my lord, reasonable, there, my lord, when the inquiry has been examined and it has been held that it has been held in accordance with law.
There
Yes.
But no, but interestingly,
victimization, my lord, is, if my lords permit me, now, my lord, if the petitioner says, if the employee says, my lord, he is an active member of a union or he is an office bearer, And then, my lord, it is not for particular misconduct, but because of his trade union activities, he has been imposed with this punishment because they don't want me in service. That is a plea of victimization. That is victimization.
Now, if you see page 16
Yes, my lord.
or 25, running page 25,
Yes, my lord. There, my lord, Hamdard Davakhana, my lord, your lordship may kindly see.
this is why once the opinion of the tribunal gross misconduct is established as required on legal evidence, in a fairly conducted domestic inquiry or before the tribunal on merits. The plea before the tribunal on merit, the plea of victimization will not carry the case of the employee
Yes,
any further.
a proved misconduct is antithesis of victimization and understood industrial relations.
But we just want.
But therefore, my lord, in this case, charge has been held to be proved.
No, let's see that, that's 5 judges' judgment on 33 to be.
My lord, that, my lord, Jaipur Jilla, if your lordship sees, Jaipur Jilla is not on this issue.
No, let's see that observation are there.
No, my lord,
Observations.
no, my lord, Jaipur Jilla, to be, my lord, if I may say so, they have reversed, my lord, Punjab breweries. Now, my lord, Punjab breweries, in fact, if your lordship sees, Punjab breweries interprets the provisions of the act correctly. Jaipur Jilla, I'm sorry, my lord, that was not the issue which was there, but then they have decided. That's an observation.
31.
Yes,
Para 14.
yes.
Where an application is made under 30 proviso, the authority before which the proceedings is pending for approval of the action taken by the has to
Yes.
examine whether the order.
Victimization, correct, my lord, correct. And my lord, the law has not changed. In fact, if your lordship sees the judgment in Hamdard Davakhana or even Bharat Ironworks, if your lordship sees page 23, my lord. That is what has been reiterated in Jaipur Jilla. Therefore, victimization, yes, if there must be a plea. Now, what is victimization? The Supreme Court says victimization is if you have been punished not for a misconduct, but for your trade union activity. That is victimization. But then, my lord, while examining that, the Supreme Court says, once you hold that the charge is proved, the question of victimization will not arise there because it's the antithesis to victimization.
But victimization is not a bona fide action.
Yes, yes.
And possibly, sometimes, a reasonable opportunity is denied. It has the color of victimization.
My lord,
It may.
my lord, denial of opportunity of participation in proving innocence, that has nothing to do with victimization.
So why say
unless, my lord, the workman says that the inquiry officer was biased. That inquiry officer was biased in not giving such an opportunity. It must, my lord, your lordships are aware, plea of bias, plea of victimization, these are all very serious charges.
Right.
Therefore, there must be a proper pleading and then proof.
That's right.
Yes.
But surely, very thin line difference between a bias and a victimization. Possibly, victimization will have the color of bias also for certain obvious reasons, extraneous reasons.
Yes.
Either I will send him out.
I'll send him out. Yes.
Procedure, I will give up. I will overlook all procedure, but I'll ensure he goes out. That become victimization, but it will have the color of bias. It will have the color of denying the reasonable opportunity.
Yes. Now, my lord, this misconduct, my lord, is a part of concerted action on behalf of this workman and several other people. Therefore, my lord, I've identified the active participants there and then taken action. That, my lord, your lordship are aware. In India navigation, way back in 1961, Supreme Court says when there is a mob, you can't dismiss the entire mob saying that everybody has participated. You'll have to identify the active and passive participants.
But let's see what is the basis for it to, who is the appearing for the appellant? Who is what is the basis to form an opinion of victimization? Here, in this case.
No, my lord, the labor court, my lord, the other side is not there. Lordship may take it up on another date, my lord. I will file the citations also and then my lord take it.
You say none for the appellant, re-notify.
Three nine. 17, Shri Karthikeyan.
My lords, I appear for the appellant, my lords.
Yes.
My lords, there is a delay of 34 days, my lords.
Yes, ma'am. Ma'am, you appear for whom?
Karthikeyan, my lords. Karthikeyan is also there, my lords, probably.
Yes, just one. You appear for?
I appear for respondent number 7 in WP number 3458 minutes. The copy that I've received, it indicates as respondent number 2. However, the online website indicates that I'm added as respondent number 7.
You collected appeals, yeah, you collected appeals. You appear in writ appeal number?
Writ appeal number 659 of 2023. It's
The same.
challenging a common order. Maybe.
That's right. Now, you appear for whom? The appellant, the petitioner before the tribunal, before the learned single judge.
I'm for the respondent petitioner.
Respondent petitioner, that's this in and out.
If I may read out the name, my lords, Messrs. Outdoor Advertising Association. In WP
Outdoor
number
Advertising Association. Outdoor is in the connected appeal.
458.
Outdoor is in 651050. You appear for the huh? For the BBMP. Now, ma'am, you appear for the other appeal.
No, my lords. Karthikeyan is there and my colleague is there on the.
Okay, okay. So common. And you were the contesting party before the single judge.
Please. In WP 3458 of 2020.
Is this issue decided by this court? Huh? Huh? So you are now bringing with the new rules? Yes. Have you seen these rules?
I need to seek
Just
instructions.
look into it. If you have anything, then. We just simply re-notify it. At the request of counsel for the appellants. You have any objection on the delay?
I don't have any objections.
These are both the appeals are delayed. Just say that these are two applications filed by the appellant seeking condonation of delay in filing the. Oh, there is only one. Okay, one only, not in two, huh? This is a 38 days delay, 1 of 23 for the reasons stated in the affidavit in support of the application, comma, the delay of 38 days in filing the appeal is condoned, application disposed of. You say, and the learner counsel for the contesting part, the respondents have no objection. In that regard, the delay is condoned. 38 days. Application disposed of, this at the request of counsel for the appellant, re-notify the appeal on
26/9. Serial number 18.
This connected matter is posted on 13/8 minutes.
Why was this not mentioned yesterday? This. We were yesterday, this had come up some connected matter, the same FIR. And there is no mention. We were surprised when we were going through this is the same thing, and there was no mention made yesterday.
Where advocate has.
List on, when is the date?
13/8 minutes.
13/8.
19. Chandrasekharaya.
Pardon? For?
Public service agency, they shouldn't notice.
At the request of counsel for the petitioner appellant, we notify.
10-9. Serial number 20, Yanam. 20.
I'm appearing for respondent 2 and 3. Corporation.
None for the appellant, re-notify. Interim order if any to continue.
23-9. 21, government advocate.
Weeks accommodation.
Right.
Seek instructions.
The request of counsel for the appellant, re-notify.
30th of August. 20. 22.
That's right.
22, Shri Ramchandra Reddy.
None for the parties, re-notify.
24-9. 23, Shri Mukkanappa.
Yes.
Initially, working as a conductor in the exponent corporation. The notification was issued for only the insert is candidate for recruitment for the post of the cost. I also produced notification at connection A. The applicant has the notification, its condition saying that the priority should be shown, but that is not to change. Once he has given the priority, in one application, he can apply, he can make an application, or more than one application, post. But you also tax in the operation. Annexure A, not you also tax in the title body. Concept is talking about annexure. Not the page 69. The applicant, the applicant cannot have applied for the full post. And given priority for the applicant. There is no respondent who has applied for the post of the applicant. Priority given at the top.
Which page you said? Huh?
What had happened was the application lost the value. The notification, there is one condition. The page 69, there was a selection method. The next page 70 not paraphrase. The candidate submit the application for more than one post. Must clearly mention the priority of the post in application. It will be selection. Consider for selection priority post file, eligibility and reservation. But here what happened was, in this case, the next page 74, you know, that is the instructions contained in the Roman page. Three, it is not allowed to change the priority even for the post in application, not page 74, actually. But in this case, what had happened was that the third respondent, the merit is to launch of practice and also produce the merit page.
Which page?
And annexure G page 113. The P. Annexure G 113. Not the launch for time is the this is also the one in the traffic inspector. And serial number 18
Who is he?
is not that the respondent. But whereas the appellate is at serial number 32. Both are AC candidates. Then I also produced that the supervisor and then the users DSI code. Page 115. The serial number 4. The third respondent is above me, shortlisted. Then serial number 6, was shortlisted, I am serial number 6.
You are 6?
Yes. See, what had happened was that the selection committee has changed the priority and selected that the third respondent in the post of the divisional secretary. Though he has given first priority to the traffic inspector, he is eligible for selection for the post of the traffic inspector.
What about you?
But I am not eligible because I have not produced the transfer certificate.
So how are you aggrieved?
My submission is if I am not, because under general merit, because it's only one post. Only one post. They given the certificate, if it is not in the proper form, it is not considered as general merit. It is only one post. Therefore, I would have been collected under the other proceeds.
No. Just tell us one thing. Were you qualified for traffic inspector?
Suppose if I am not qualified, because I belong to scheduled caste, but I have not produced the certificate. Certificate is not
Certificate for?
verification.
For verification.
Yes.
Then you could have applied.
Considered.
So that's the only this thing impediment before you, that you don't have the certificate.
Yes, he is eligible. If he has been selected, I would have been selected in general merit and in the division.
But you applied for a reserved post.
That's the reason candidates are permitted to apply for.
That's right. Now let's test it.
What had happened was now the wellness secretary forced that the committee, since selection committee has changed it time because they have not given that the lordship candidates.
See, you will not look at change of priority. You will look at for simple this. You applied for against a reserve seat. You applied against a reserved.
Yes.
That's right. But you were not fulfilling that eligibility because you did not have the certificate. Now you say that you should be considered as a general candidate.
Yes.
That's right.
Yes.
Now when this priority is only for the post, for the category you have applied for.
But priority is suppose what happens is the procedure what they followed it. Suppose if I am not been selected for the post of a traffic inspector, then they will be to the next candidate, whether I am entitled or not. If they are eligible, they will consider. Otherwise, will not.
See, it's like this. Now let's test it. You say, since you didn't get the bring the SC certificate, you should be treated as general. 1 minute. The category is being changed from an SC category to a general category. That's right.
The change of category is not the category. Post he has changed. And that's the issue in modern.
Post means?
Post means your lordship can see the application. It reaches the issue. Annexure B, not your lordship, that is the application filed by me. In translated copy page 83, your lordship, that is. This is the only issue. Page 83, your lordship, that is.
What you are arguing is the priority has been changed.
Yes.
Now tell us one thing, that's what we are saying. Priority may have effect of changing the priority, but the fact remains for that SC post, you were not eligible because you didn't have the certificate.
That's it, no,
That's right.
It is true, my lord. What happens is, suppose if he has been selected in traffic inspection post because he is also an SC candidate, I would have been selected, my lord.
If you had the certificate.
That's why the lordship can see page 83, I'm sorry.
Yes.
The post applied for on priority basis, your lordship.
Yes.
The traffic inspector, then account supervisor, divisional security inspector.
This is whose application?
This application by me.
Okay. Traffic first, not traffic, then account supervisor.
Divisional security inspector. Then the lord, your lordship, can see the application filed by the third respondent. Page the page 98. Balaram Lamani, because the post applied for priority basis, traffic inspector and divisional section. Now, my only grievance is, since his priority has not been changed by the selection committee, that is not permissible in the. Then my lord, the natural have been selected in that.
Now, to which post to which post he has been selected this?
Now he has been selected in divisional security inspector.
Oh, he has been there.
Selected under the traffic inspector post. Now, selection committee selected him under the divisional security post for the post of division.
Oh, we thought that traffic inspector. He could have been appointed as traffic inspector.
Yes. He has been selected on that post, the next candidate, this man is selected in traffic control, I would have been selected. Now the selection committee may not be watched, can you see?
That divisional is also against a reserved post?
Yes.
Now tell us one thing.
Can you see?
But tell us.
No, you watch, but can you see what the page 57. 56 is the, not the notification, page 57. The traffic inspector, sorry.
57, huh?
Yes.
Yes.
The traffic inspector. SC one post. General candidate one, there are two posts in rural. Serial number 3.
Ruler.
Traffic inspector.
One woman, one ruler.
Only one post. SC post is only one post. No, page 58, you know, times.
SC is one post means?
Now, in page 58, you lost time. This is the divisional security inspector. There is only one post, you know, this is for the
General.
general.
Is it? No, it's not for general. It's for, why, no, it says SC. No, it is for SC. It is for SC. Mr. Mukkanappa, it is for general. No, it is for SC. Don't go by the general. But it says general, woman, ruler, soldier. These are the quotas reserved for those people. General is anyone can compete. Woman means only woman. Ruler means only ruler. Retired soldier means only retired soldier. Provided But why retired soldier is no, I said there is no post for retired soldier. No, GC is there. GC is there in the first. Okay, let's see divisional. So it's general, everyone can compete, but he should be provided he is an SC. Now, let's test your argument. You also applied for divisional security inspector. Okay? You also applied for traffic inspector. Traffic inspector as an SC candidate, you could not come in because there was no certificate. Okay? You have applied the next post also of accounts.
Yes.
You did not meet it. He did not apply for accounts. But he applied for divisional security inspector. Was he next in the merit?
Yes.
Very well. Now let's test it. You could not have qualified for divisional security inspector also because you didn't have certificate.
Then argue only on this guarantee basis.
You're right. But what we are asking you is, what affected you in the traffic inspector will also affect you in divisional equally because you didn't have the certificate. Now it so happens you didn't have, maybe you are higher in merit than him, but you didn't have certificate, you will go out. The next one will come in the priority. Maybe that must have happened. What is the finding of the learned judge?
Para 13 man. Eligible.
See. No, we'll just. You applied as a ruler. You applied as a ruler. Now tell us. I know you're right. See, what they say is, this respondent number 3, you applied for ruler. Though you had more marks, but his selection was SC general SC. So even for, there is no post for ruler. So you can't have any claim for divisional security officer. You can't. Which is that? No, which is the priority, next priority? For divisional, but you applied for general divisional security. Para 12. Yes. What is the change? Oh, he changed from traffic inspector to, but it was not the application, his application for priority. No, but as a priority, he has given divisional security. No, but tell us one thing, at least what we have now. Let's test his eligibility and selection for traffic inspector. Now, what they have said is, traffic inspector, he got 41.22 marks. The person who got a higher 41.3 odd, he got selected for. So he got in as traffic inspector. Now his priority is, the next priority is divisional, this post. For which post? Can we read that para 12 once again? Para 11. If you see 11. Now let's stop here. So you applied for traffic inspector and that divisional post. under SC ruler? Okay, very good. Now, so what, now read further. The petitioner and said Mallesh Nayak So this is for your traffic inspector. So the respondent number 3 is not in picture here. Okay? Because there is Mallesh Nayak is above the petition, respondent number 3 in merit. Because the respondent number 3 got 42.30, but this Mallesh Nayak got 42.70. So he is higher in merit. He got 41 point. Okay, but this is, I don't know. Oh, they have given up the post of here. Okay, okay, let's take it. So he did not opt for traffic inspector. He opted for divisional that. Let's now come to para 12. Now 13. Now, but now sum total is, but the fact remains you are an SC ruler candidate. Let's go by that. Now, now read para 14. No, but the fact remains, this divisional security inspector was not reserved for ruler SC. It's true? Then you are not a contender. General SC, not a ruler. So you are not a contender. You are not a contender. How? You are a contender, but that's not the case. No, but see 57. See page 57. 58. 58 is only for general. That's right. It's not ruler SC. So how are you a contender? But that post, that post is not meant for SC ruler. Simple. So then that's all. You are right. But you are, see, you don't have for ruler certificate. Now SC, now even traffic in. It's not required, you are right. Okay. Okay, okay.
That's why
so even certificate now there is general then. But tell us one thing, that certificate, whichever certificate is with you, that holds good for SC general? Yes, ma'am, what do you say?
Yes,
Yes,
one. Even at the SC general, my lord, his percentage is lesser than third respondent.
Pardon? No,
And
if you see that, his merit appears to be higher than the third respondent.
no, it's not.
It's not. Let's
No.
see that. Is it a fact, Mr. Munbat?
No.
Yes, it is into 8%.
Then I think we should.
I would have considered that because he will not be there, they will not be there, but the selection was the first time. Then I would have been selected. I am the only candidate.
But let's test this argument. You are saying you should be considered for Divisional Security Inspector General? And that's a valid argument, provided your merit was above respondent number 3.
He has not changed his development. That's the reason why he has been here. I have not been selected for the post of he has been selected. He has opted for if he has already been here, opted since he has opted for
But tell us one thing, for traffic inspector, respondent number 3 was the merit, the topmost merit.
Yes.
Then who comes whom? Then the petitioner? No, he did not opt. We are testing your argument. He did not opt. Who is next in merit?
Next is I.
Provided,
Yes, I did not select it because I want to.
provided you should have given your ruler certificate. No, we want to understand this notwithstanding. How would you come in? Because the post is meant for general, not general, ruler SC. No, general SC, you are right. So if it is general SC, it will be the person who is more meritorious, forget the ruler certificate, who is more meritorious would come in. Obviously. But you are less than the merit of respondent number 3. You know,
They would have been selected.
yeah, right. What you are saying is if we had not given up the post of traffic inspector, you would have come in as the divisional security officer. If that be so, once you have applied for traffic inspector and you are not eligible for divisional security inspector as a general, you would be eligible. A valid argument, but the only thing is, the merit he has come in.
Reasons assigned for page 28, selection.
No, we have understood you.
Selection committee reasons assigned for.
Which page?
Page 28.
$180.
Page 188.
Yes.
Separate application for each. They are not given priority to use. Some of the candidates are not eligible for the post of the year. Therefore, the committee has decided to consider the selection by taking priority for the eligible post to the education. That is not the situation. It won't be good. He has given the priority. That is the reason I argue the
And tell us one thing. Once a person has given priority, does he have a discretion or a right to say that I will not accept traffic inspector? I will go for the divisional security.
No, it's not available, my lord. But what happened when the when the selection committee verified, my lord, so the candidates who were more meritorious, my lord, for one, they had applied separate applications for each post, my lord. For example, my lord, the petitioner, my lord, he comes in the first, my lord, in all the three. Applications are filed, my lord, separately. They should have filed a single application. In that, my lord, they should have given priority 1, priority 2, priority 3. My lord, when it was noted, my lord, there were meritorious candidates, my lord. And they had separately, they had filed 3 applications. 1, 2, 3, my lord. Separate applications. And some, my lord, had not given the preference, but they stood in the merit list, my lord. They stood. So therefore, my lord, the committee decided, my lord, to give preference at the time of to all the candidates, including the petitioner. Only, my lord, by this effort, my lord, I demonstrated before the learned single judge, my lord, by placing all the original records, how the selection took place, my lord, and by giving only, my lord, preference to the merit candidates, my lord. Only persons, my lord, who have a high merit were
Prejudice it has caused to him is.
Yes, my lord, I understand.
Once he has given up the security traffic inspector, his case for this general, the divisional security.
My lord, he would have been selected, his case.
But if he had been selected in that,
yes,
this would have become vacant for him. That's right.
Yes, my lord, that's his case, my lord. But the selection committee, my lord, has not in respect of one person's, my lord, to all the candidates, my lord. Option was given, my lord, at the time of verification of the documents. And only, my lord, and I have demonstrated showing that, my lord, because, for example, my lord, he had in divisional security inspector, my lord, which post he is claiming, his percentage is 42.70, my lord. That of the petitioner is, that of the selected candidates is 45.21, my lord.
That's right.
So therefore, my lord, the meritorious candidates, my lord, were chosen, my lord. So therefore, my lord, no injustice has been caused because he's only taking a stray incident, my lord. But in by and large, my lord, in the entire selection process, it so happened we have the highest meritorious candidates, my lord, who have not opted 1, 2, 3, my lord. 3 separate applications. I do not know because all the 3 come in one in serial number 1 only, my lord. I cannot, as a selection committee, my lord, I cannot take their claim for one post, my lord, traffic controller, because they are equal in all the three. They're number one in all the three, my lord, not given preference. Like this, my lord, there were several applications, my lord. It so happened, that's the reason, my lord, the selection committee, my lord.
It's not only solitary case, there are many.
No. It's not. I've demonstrated, my lord. I produced the verification sheet of each of the candidate, my lord, before that which has been extracted, my lord. And a copy has been given to him, my lord.
Which page? 58.
Now even priority was topic is applied for on priority basis. Topic is better.
My lord, I'm not saying in his case, my lord.
In such a situation, later, yes, but that's not the situation here. He has also given priority, I have also given. There is no more than one application was filed by either of them. In such a situation, consideration does not happen at all. That's why we are.
My lord, can I read again, my lord? Can I read the proceedings of the selection committee, my lord, at 188? Some candidates have submitted separate application for each post. And they have not given priority of posts. Some candidates are not eligible for posts which they have given priority. Therefore, the committee has decided to consider for the selection by taking priority for the eligible post during the verification of documents. It was kept open for all, my lord. So in the result, my lord, the selection committee, my lord, has selected the persons, my lord, who have meritorious candidates, my lord.
So one application, 3 priorities,
Yes, my lord.
but different applications for different posts.
Different posts, my lord. My lord.
But tell us one thing, suppose he has given 3 applications. There is no priority there.
The priority is not there, then the selection committee is not, the decision maker is correct, but that's not the situation. That's the reason. I can understand if such a situation is yes, selection committee has got.
Totally, there were 531.
So
posts.
actually
The selection was being done.
ideal situation is 1 application, 3 priorities.
Yes.
Not separate applications.
And 534, totally, my lord, 550. My lord. My lord, in fact, 500 No. My lord, I'll clarify that. 551 posts were notified, my lord. There were 551, my lord. It's not solitary. If your lordship could see page 174, my lord. It was for various posts, my lord. The selection committee, my lord, was the common selection committee, my lord, for the entire post which was notified. Page 174, my lord. If your lordship could see, my lord.
But are you coming up with any fresh advertisement?
My lord, it so happened, I submitted, my lord, what my learned friend said that there are vacancies. My lord, it so happened, my lord, the corporation, my lord, was bifurcated, my lord. In fact, trifurcated. 4 corporations were formed, my lord. That was in the year 96, 97 and 99. Those notifications forming 4 corporations was called into question, my lord. Matter went up to apex court. 2014, my lord, the matter was decided, my lord. All the 4 notifications forming 4 corporations were upheld. And then as a result of which, my lord, I had to, my lord, allot permanently the officers, my lord, that is the class 3 and class 1 junior post, my lord, to all the 4 corporations permanently. This comes under class 3, my lord. The vacancy which he is saying, during the allotment process, my lord, which took place in January 2023, my lord, entire allotment has taken place permanently, my lord. The posts have been allotted. Therefore, my lord, I submitted to the learned single judge, my lord. That was in April 2024, that no posts are available.
But Mr. Mukanappa, they tell us one thing, come to 188. See the predicament of the selection committee, finding that 1 application, 3 priorities, they have submitted 3 different applications. Not only confined to this, it confined to other candidates also. In that scenario, they said very well. They have not given even priority for posts. Some candidates are not eligible for the post which they have given priority. Committee has decided to consider of the selection by taking priority on the eligibility. there is some basis and the learned judge has taken a view. Unless you say that this is something, totally mala fide, this selection committee's change. And see, I'll tell you, just imagine once, just for a moment, just think that you are part of the selection committee, you are found with a situation that one application, 3 priorities as against that 3 different applications for 3 different posts. And you are considering the people for those posts also. What will you do? And the selection committee, I think, it's a big composition. If you see the selection committee, there are 10 members, 178. Not 10, 11 members. They take a call, look here, they have given application now only on this technicality, they should have filed only 1 application with 3 priorities or some priorities. We should not reject it, let's do this. Unless something which is mala fide, very difficult, or at least there is some view which has been taken by the learned single judge. You may be right in saying so. If he had not shifted from traffic inspector to this, that would have come, the next post would have come to you. Being in the merit and being a general SC. There is some view which has been taken, and not mind it. This is not only confining to this post. There are other posts also. Other posts also.
Totally fine.
Something level playing field. See, any observation of ours will have a bearing on all other posts where this process has been undertaken. No, you are right. Or you should say in future, one application, priorities, more than 1 application rejected.
Yes.
Reject all the
We are
applications.
doing that, Milon, now.
So
After
that
this-
at least the confusion.
Milord, after this, the notification, the advertisement has been, Milord, amended, Milord. It's, now it is properly worded.
Must be there and adhere to it. More than 1, reject. So that this confusion goes. See, he may be right because ultimately, and once you are going by the priority, if he has taken it, you will adhere to your priority. You can't shift out. That shift out is, they see there is a legitimate expectation. Look here, you will take that, this fellow will take that, I will get this expectation.
Yes.
Not in these facts. No, are you coming out with any advertisement? But the only thing, Mr. Munakam, the only thing is, as and when they apply, you apply. You are not age barred, you are an in-service candidate, this recruitment is for in-service. How much years, what is the age?
He's now 47, Milord.
Huh?
He's 13 years left, Milord, still.
Huge service you. Not in this fact, I don't think we should. Okay, but that's a valid point you have taken, you're right. But I think going by what the ministry, selection committee has thought, it's not a one-off case. It's across the board for all positions. The challenge in this appeal is to an order dated 13th July 2023. Passed by the learned single judge in writ petition number 44270 of 2018, whereby the learned single judge has dismissed the writ petition by stating in para 13 and 14 as under. We have 14 as under. Some of the facts which are required to be noticed are that the petitioner, the appellant herein and the respondent number 3 were working as conductors in the Bangalore Metropolitan Transport Corporation, bracket the corporation. The corporation issued notification dated 12/12/2012 for recruitment of class 3, Woman 3 posts for in-service candidate. Pursuant to which the appellant and the respondent number 3 applied for grade 3 post as in-service candidates. First, the appellant had applied for 4 posts based on priority, viz. Traffic inspector, account supervisor, divisional security inspector, and storekeeper. Full stop. Whereas the respondent number 3 had applied for 2 posts, traffic inspector and divisional security inspector, which was permissible under the notification. Full stop. Next paragraph. The respondent number 3, in the merit list was above the appellant in respect of the post, in respect of traffic inspector as well as divisional security inspector. Full stop. The grievance of the petition appellant before the learned single judge was, though the appellant had applied for 4 posts in the priority and respondent number 3 applied for traffic inspector on priority, the respondent number 3 being eligible for selection to the post of traffic inspector was selected for the post of divisional security inspector by modifying the priority of the post. Full stop. It is noted that the corporation had filed objections, objection before the learned single judge. Be that as it may, the case of the appellant as contended through his counsel, Mr. Mukanappa, that the respondent number 3 having expressed his priority to the post of traffic inspector, he could not have been allowed to shift his priority to that of divisional security inspector. Full stop. According to him, the same has caused prejudice to the appellant in as much as if the respondent number 3 had been appointed on the post of traffic inspector, the post of divisional security inspector would have been offered to the appellant hearing. The learned single judge, while rejecting the case of the appellant as in paragraphs 13, in paragraph 11, 12, 13, as also stated as under. Full stop. The full stop. The justification for rejecting the writ petition by the learned single judge was on the basis of the proceedings of the selection committee. Selection committee, more specifically at page 188 of the paper group, wherein the selection committee has stated as under. Tick to tick, page 188. The submission of the learned counsel for the appellant before us also is also similar to the one which has been advanced by the learned before the learned single judge. Though the plea of the learned counsel for the appellant looks appealing on a first blush, but the fact remains that there were many other applications. But the fact remains that there were many other candidates who, instead of submitting one application with priorities, had submitted different applications. Full stop. It was under such circumstances, the selection committee had taken a decision which we have reproduced above. So in other words, that it is not in the case of the petitioner oblique respondent number 3 that a candidate was allowed to change the priority of the post, but for other posts also a similar decision was taken. This is clear from the minutes of the selection committee which we have reproduced above. If that be so, we are of the view that the conclusion drawn by the learned single judge in the facts of this case, need no interference. This we say so that the procedure followed by the learned single judge was not confined to one post, but others as well. Full stop. We are of the view that no interference is called for with the order of the learned single judge. The appeal is dismissed. Thank you. Next one.
Before Shri Narasimha Raju.
Yes. Just one. He come there. You have got that death certificate?
The affidavits are ready. I've served the learned SPP as well. They said they'll remain present at 2:30 before your lordships.
Just get it listed.
The death certificate is at page 5, your lordship. And the father, who is also the petitioner herein, has sworn an affidavit at page 3 and 4.
Who had filed the petition? The father?
The father. The father is the petitioner.
Yeah. This would suffice the hospital certificate.
Your lordship, that's
The burial has not taken place, no?
it's not taken place. They are waiting for the body. They are waiting for the son.
We'll have it at 2:30.
Grateful, your lordship.
Yes. You have filed the translation of the documents? Yeah, appears to be. Yes. Yes. How many? How many?
194. Totally 194.
And how much, what was the charge now?
My lord, non-issue. My lord, this non-issue of tickets, my lord, non-issue.
Many?
15%.
This is a perennial, I think,
My lord, what happens? My lord, in the present case, my lord, I just know that's the reason I was delayed for the previous case, my lord. I went to collect the information in this case after the reinstatement, my lord, till his removal from service. That is after the learned single judge has upheld the order of dismissal. Therefore, he was taken, my lord, pursuant to the interim order. And he has been, my lord, the duty has been stopped, my lord, on 3/10/2023. And from the date of reinstatement till the date of his duty was stopped, he's involved in 20 cases. And the day on which, my lord, he was stopped duty, my lord, he was suspended from service. Then he approaches this honorable court, my lord, in the writ appeal and secures an interim order that he will be removed. In fact, I'm seeking, my lord, pressing of his reinstatement. Even if he, because by the time the interim order was passed, my lord, staying the operation of the learned single judge, he was already, the duty was stopped, which he was aware of it, and he was under suspension. That's the reason, my lord, I wanted to place it on record, and they've sent me, my lord, all because it was in Kolar, my lord. He was working in Kolar. They sent the history sheet, my lord, and he's involved in 20 cases.
Even after reinstatement, after this, the order.
Yes, and when I was not aware of it, otherwise I would have brought it to the notice of the learned single judge, my lord. The day on which he was stopped duty, my lord, he was under suspension in a pilferage case. My lord, I think they may have to file an affidavit. My lord, can I just
File an affidavit, bring it
Yes,
on
my lord.
record.
Can I just pass on to your lordship on judgment?
Not the affidavit.
No, on judgment, my lord, where the reinstatement was done, my lord. And the Honorable Apex Court, he was removed from service, my lord. The order
File
of,
an affidavit.
yes, my lord. The order of dismissal was upheld by the division bench, my lord, against which the workman carried to the Apex Court. Apex Court, my lord, has held that an affidavit has been filed showing even after reinstatement, he was involved in so many cases. Therefore, the Apex Court held that he was incorrigible, my lord, and the order of dismissal was.
Just say that learner counsel for the respondent seeks and is allowed how much time?
My lord, I'll file it today itself, my lord.
Affidavit.
Yes, my lord. I'll prepare it, my lord. I'll file it by tomorrow.
A week's time to file additional affidavit. Let the same be filed with, by giving a copy to the counsel for the
Yes.
appellant, re-notify all.
14-8,
Next.
25, Shri Prasanna BR. 25.
He was working in a scheme. Notice issued on this.
No, sir.
Is this, but in any case, he has attained the age of superannuation. When? But when did you disengage him? When did you disengage him? Was he disengaged or what? Up to the age of retirement. But against that scheme only. Even the scheme is still continuing. But what has been directed is the all as a regular employee. Para 17. But the scheme doesn't involve a pension. Issue notice. So and so accept notice. Two. Let notice be issued to respondent number one, returnable order.
2110. 26, Shri V.S. Nayak.
I appear for the appellant in this matter, Your Lordship. The appellant was a conductor and was dismissed from the services, Your Lordship.
Yes.
And was dismissed from the services against which the dispute was raised before the Labour Court under section 10(4)(a). The dispute was dismissed, Your Lordship, and before the Labour Court, sorry, Your Lordship, before the learned single judge, the writ petition was also dismissed and the punishment was upheld, Your Lordship.
What was the charge?
Charge is, Your Lordship, at page 34, Your Lordship, translated copy. Certain irregularities were found in the ETM, Your Lordship. It's not a case of pilferage. You're supposed to issue pass to the journalists traveling in the bus, Your Lordship, and their number was to be, pass number was to be entered in the ETM. Page 34 is the translated copy, Your Lordship.
Yes.
See charge 7, Your Lordship, that gives the explanation. It says that you have misused the general standing order number 789 of bar 212 dated 14/2/2012 and 24/2/2012 Tippani directions. Even though the tickets are issued to the journalists from them, you have not taken the money and to them issued ticket amount to be paid to the depot. Payable total transport income is cut down and payable opportunity. Actually, Your Lordship, this translation is written wrong. Actually, what is the procedure is explained at page 50, Your Lordship. 51. 51, Your Lordship.
Yes.
Original one and translated is at page 73.
Yes.
The corporation also issues the number to the journalist, Your Lordship, along with the number of the journalist guild. There it is 73, Your Lordship. That is the proper explanation. In Exhibit K, Sridhar K. Sridhar, conductor badge number so and so, in his written statement that he for about 2.5 years have discharged his duties as a trainee conductor in depot number 5 and have worked mostly in Mysore-Bengaluru route. And from 1/4/2014 to 2/6/2014, in route number 53/54 from Bengaluru to Mysore, route have worked. And while on duty, to the journalists who come in his vehicle, their passes are checked and the tickets are issued to them. And sometimes the said journalist, without showing their passes, talking indecently, saying that, don't you know that I'm a journalist? Do you want me to tell again and again? Saying so, they will sit in the vehicle, and that time then the pass number mentioned by them is entered in the ETM machine and have issued the ticket. And I have never knew properly to take out the journalist pass from the ETM machine. Sometimes the journalists themselves have told me that in this manner, take out the ticket, and have told me about the option. With regard to the issuance of the journalist pass, I am not given proper information, and during the said period, I have discharged my duties, and I don't know how the mistake has cropped in. So, Your Lordship, the journalist pass, they have to show to me and to enter that pass number in the ETM, and taking the money from them, lesser amount of the ticket amount has to be taken from them and paid at the end of the day to the account section, Your Lordship. That is what the procedure is followed. And what the MW2 has said, Your Lordship, the bus was not checked. It was the back-end report when the ETM was submitted at the office. That back-end report is looked into by them, and based upon that report, they have charged this. They have issued this charges, Your Lordship. The back-end report, I have explained, Your Lordship, the pass number were entered by the journalists by themselves sometimes or whatever without showing their pass ticket. They have I have entered the number whatever is mentioned by them, Your Lordship. So there is no case of pilferage, Your Lordship. Whatever was amount was collected by me is submitted at the counter, and while I submitted at the counter, back-end report was looked into and ATM from the ATM machine, and the amount was also taken. There is no irregularities found at that time, Your Lordship. Subsequently, they found out that if the pass numbers are entered in the ATM are not matching with the pass number issued with the journalist. After that, this charge sheet is issued to me, Your Lordship.
We will continue after lunch.
Please. Your
Lordship, submission, Lordship. List number 1, serial number 20, Lordship. When his case is called out and end up in some other court, I kindly interim order to be extended, Lordship.
There is interim. This is Annamma.
Please, Lordship.
Annamma Kurpa.
Please, Lordship.
If there is an interim order, that will continue. We have given a date. No?
Yes, sir.
Yeah, 23, Lordship.
Just interim order if you need to continue.
Much.
Thank you.
Please.
Serial number 15 in date ಯಾವ್ದು ಮೇಡಮ್?
ಈಗ ನೀವು ಹೋಗಿ ಇದ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅದೇ, ಹೋಗಿ ಮಾಡಿ.
Two 30 more matter.
Yes, you have seen that.
Yes, yes.
You say.
I cannot possibly have any objections to that. But my lord, the heinous offences, there are certain heinous offences which are committed by him. So my only request is that he would attend the funeral with an escort by a specific officer who is called as a litigation conducting officer. So therefore, yes, we'll do that.
Only what are the rituals you have to carry? Yes, rituals.
Your Lordship, the rituals have not been specified, but when I inquired with the family, they told me that they'll need him for 3 days.
Lord, 3 days would be too long, Lord. Because the offenses, Lord, he's been absconding. In every offense that he has committed, he has absconded. And the offense that are one of dacoity, robbery, extortion. So therefore, yes, of course.
May I suggest one? Yes. May I just inquire, Your Lordship? 1 minute, Your Lordship. If
Yes,
I'll just seek instructions. One.
Your presence is required.
Very well. Yes, I'll just do that.
There are 6 matters where absconding charge sheet is filed. So body warrants have been issued.
Your Lordship, I'm told that today the burial will take place. Tomorrow they'll have to feed some people as part of the ritual. And day after they'll have to make floral arrangements over the grave of the concerned person. So for these reasons, he says that he'll be required for 3 days.
What time? Will be possible. Is it now? At what time?
Yes, because as otherwise the rules are stringent. If your lordship direct. Yes, your lordship may direct. Direct the IGP prisons because he is the authority who would entertain the parole applications. Your lordship may direct him to release with the conditions that he would be escorted by the litigation conducting officer.
Then he'll be escorted by.
Yes. Yes, yes, ma'am. Yes, ma'am. Yes.
Suggesting this, is it possible? That in the night he comes back and morning you can take him.
Yes, all 3 days we can do that.
That.
Yes. ma'am.
Very well.
Yes.
I'm agreeable to that, Your Lordship.
Yes.
Application.
ಇದು ಅಡ್ರೆಸ್ ಕೊಟ್ಬಿಡಿ ಅಡ್ರೆಸ್ ಎಲ್ಲಿಗೆ
Father of the detenue, Your Lordship. Yes.
The petitioner who is the father of the deceased.
Yes.
It is a prayer that the deceased released For a period of 3 days, for only these brothers last rituals, it was discussed. The continuing is under preventive detention. So it is stated in the application that the mother of the detainee, that is the wife of the petitioner, has expired on 6/8/2024 at 3 p.m. In support of, in the application also annexes the death certificate issued by New Aswad Hospital. The issue was made by the petitioner about the listing of the petition. Today, in view of the evidence, the appears for the respondent would submit that when the facts as covered in the application, we cannot really vehemently oppose the claim that has been made. The only request is that the detainee be released, given the facts of the case, the detainee be released under an spot. Under an spot to carry out the rituals as required. The specific query to the counsel for the petition, we can state on instructions that the burial is scheduled for today at what time.
They're waiting for him to be released.
We should do today. So there is a ritual which is to be performed tomorrow
Yes, tomorrow and day after.
and day after. We saw from we direct the we direct the
Third respondent. Third respondent.
Inspector General Police Prisons.
for enabling him to perform the rituals on today, that is 7th August 2024. Tomorrow, 8th August 24, and day after tomorrow, 9th August 2024. Instead of the release, on release from the detainee shall be accompanied by 2 plain clothesmen. 2 policemen in plain clothes.
Yes.
Plain clothes. So it is agreed by the officer of execution and SPP that on completion of the rituals today, that is on 7th August 2024, the detainee shall be brought back. Where is he otherwise in the detention?
In the prisons, Bangalore, Parapanagara.
Stop. He shall be taken to the for rituals to the where do you undertake the rituals?
At his residence is what I'm told. See, Your Lordship, I'm told that all those rituals will be performed at their home, the rituals tomorrow, and day after it will be at the burial site. Yes.
Where on completion of the rituals, he shall be brought back to the prison.
Before sunset, bro. Yes.
One clarification, Your Lordship, on the day after, he is supposed to go to the burial site to lay flowers on the grave of the mother. Yes.
Will you be able to perform today?
I'm told that they're waiting, Your Lordship, for him to be, they were waiting for the order, the outcome of this.
It's made clear that this order is only till 9th of August 2024.
And Your Lordship, may I just make one more request?
Till the evening of 9th of August 2024.
Yes.
Your Lordship, one more request. Even if we, may I request the registry to send the operative portion of the order to the respondent number 3?
Yes, Lord. We will call them and see that preparations are.
We try to give it. Just try to give
Submission
it.
is, sir, ಇದು
Possibly you can.
the
The liberty is in the registrar judicial of this court shall orally inform the Inspector General of Prisons about the order passed by this court.
yes. Yes.
Liberty is also granted to the SPP to send to communicate to the IG prisons the order passed by this court.
Yes.
To a written communication.
Yes. Lord, the police, yes.
Yes, tell us.
The police personnel of litigation conducting officer, that is police inspector of Koramangala will monitor. Two police, yes.
Gentlemen would be able to speak.
Great.
The plain books.
Yes.
Yes, do this. We will also try to, sign the order as fast as possible.
Yes. Yes.
Possibly by 3:30 you should get it.
Yes.
Grateful. Yeah.
Not take him in handcuff.
No.
I'm most grateful, Your Lordship.
The matter is scheduled to listed tomorrow. So it could be, the matter otherwise is scheduled to be listed tomorrow.
It's listed.
Yes.
I'm grateful.
See tomorrow.
It's not there. Is it the application which has come?
No, as otherwise, tomorrow it is slated to be
I'm
listed. Yes. Yes.
Take action.
Yes.
most grateful, Your Lordship.
Next.
Serial number 26, Shivyas Naik.
Please, Your Lordship, appear for the petitioner, appellant, Your Lordship. The case I was submitting, Your Lordship, this is the free pass issued to the journalist. There was some irregularities conducted by the.
Yes.
And the procedure is, Your Lordship, at page number 71. I was explaining, Your Lordship, how the bus pass, free pass entry issued to the journalist has to be entered in the ETM, Your Lordship. At page 71 is the.
Tell us one thing.
Yes, Your Lordship.
Is it your case that the journalist has not undertaken the journey?
They were, Your Lordship.
So then.
They were, and their pass numbers were to be entered in the ETM. And
Yes.
I need not have to collect the amount from them because it's the free bus pass. And at the end of the day, Your Lordship, I have to submit the ETM machine without the amount collected from them, Your Lordship. And the back-end report will be looked into by the accounts officer. And the back-end report, they say that the entries made about the bus pass of the journalist in the ETM did not tally with the bus pass issued to the journalist.
Yes.
And my explanation is, Your Lordship has seen at page 74, Your Lordship.
See, come to page 74.
Please, Your Lordship. I was about to read. That start with page 73, Your Lordship. In exhibit case Sridhar. That is my explanation, Your Lordship.
Yes.
Inquiry officer. In his written statement that he for about 2.5 years have discharged duties as a trainee conductor in depot number 5 and have worked mostly in Mysore-Bangalore route. And from 1/4/2014 to 2/6/2014 in route number 53/54 from Bangalore to Mysore, 6 round trips. Route have worked, and while I was on duty to the journalists who come in his vehicle, their passes are checked and the tickets are issued to them. And sometimes the said journalist, without showing their passes, talking indecently, saying that, don't you know that I am a journalist? Do you want me to tell again and again, saying so that they will sit in the vehicle? And at that time, the pass number mentioned by them is entered in the ATM machine and I've issued the ticket. And I have never knew properly to take out the journalist pass from the ATM machine. And sometimes the journalists themselves have told me that in this manner, take out the ticket and have told me about the option. With regard to the issue of the journalist pass, I am not given proper information, and during the set period, I've discharged my duties and I don't know how the mistake has cropped up, and further said that if there is any slackness or misuse, I am responsible. And for a moment, Your Lordship, page number 71. That is how entry should be made in the ATM machine, Your Lordship. On verification of exhibit G to G2 document, the journalist, while traveling in the corporation vehicle, the corporation to them issued pass and the information department issued an ID. Both is to be verified, and the conductor over the pass printed corporation issued number, for example, BNG 264 is to be typed on the ATM, and later on the ticket is to be issued to the journalist travel distance, and the ticket amount is not paid by the journalist. Instead, the conductor, while making the payment in the depot, pay the lesser amount for the journalist issued ticket amount.
Yes.
Lordship, I issued a ticket to them taking their bus pass number in the ATM, but no, for the ticket is issued for the distance traveled by them, but no amount is collected by them, Your Lordship. And at end of the day, deducting that amount, I have to pay because that amount is never collected by me. They are free bus pass journalists, Your Lordship.
Yes.
So my limited argument is, Your Lordship, it is not a case of misappropriation. There is a procedural.
Yeah, let's issue notice.
Please.
Issue notice.
2310, madam.
Much obliged.
Take this also.
Twenty-seven.
Yes, ma'am. Yes.
Yes.
Responses.
27.
It's a delay of 25 days. 25 days in filing the writ appeal. 25 days in filing the writ appeal.
What is on merits?
Merits, Murad, the appellant was a driver and he met with an accident while in service and while on duty, Murad. And the medical board certified Murad is unfit for driver. And at the request of the appellant, Murad, he was assigned light work. But while assigning light work, Murad, he was his pay has been fixed to the post he was assigned, Murad. He was deputed to work as an attender. Instead of protecting the pay scale, Murad,
they did not protect.
Did not protect the pay scale. Then, Murad, subsequently, Murad, he was referred to the medical board. Then medical board again issued disability certificate certifying that he is suffering 40% disability. Then, Murad, the respondents have not have to extend the some benefits like vehicle allowance and other conveyance allowances, and protection is also not protected. Therefore, Murad, he made a representation, but this representation was not considered. Then he approached the labor court. Labor court, Murad, Lordship, kindly see operative portion of the order at page 88, Murad, directed to pay the some difference of conveyance allowance and vehicle allowance and other difference of salary in the respect of not protecting his pay scale. Page 88, operative portion. It is ordered that the appellant is entitled for conveyance allowance at rupees 200 per month from the date of accident till 9/10/2009, and he is entitled for rupees 400 per month from 10/10/2009 to 7/7/2014, and he is entitled for 6% of his basic pay towards vehicle allowance without upper cap of from 8/7/2014 onwards. It is further ordered that
The appellant is entitled for applicable pay scale from the date of accident and the difference amount after deduction of the amount paid already. It is further ordered that the appellant is entitled for 6% interest on the such difference of amount in the pay from 10/5/2013 till realization. Aggrieved by the same, my lord, the corporation has filed writ petition. The learned single judge, my lord, held that, my lord, he is entitled for benefits only from the date of production of a disability certificate, that is in the year 2016 onwards. My lord, in fact, my lord, at the time of requesting for light work, he was referred to the medical board, and medical board has issued an unfitness certificate. That itself is sufficient. On the basis of unfitness certificate, my lord, he was assigned light work. And even though he was assigned light work, my lord, his pay scales have not been protected.
What does the single judge say? Did you go to the labor court?
Yes, my lord.
What does the labor court say?
Labor court tells that, my lord, he is entitled for pay protection. And since he is
Issue notice.
24/10, sir. 28, Sunil Shastri.
I appear for the respondent in this matter.
My lord, be pleased to pass over the matter. Senior counsel has just.
That's I will start, my lords. The reason I'm
28.
requesting that I would start is that, my lords, it has been adjourned on the ground that senior counsel is not available or senior counsel is not there. I would just take.
What is the issue?
My lords, the issue here is that, my lords, they have challenged 2 orders of the arbitration tribunal, which, my lords, are called in question in this writ petition. My lords, would get.
Tribunal in which, under which provision the application was filed?
That's the application. Let's make this. Arbitration tribunal was constituted by this court, my lords, under section 11(6). Subsequent to which the mandate was given to the arbitrator, one Justice A.
Is the order passed? What is the order and the challenge?
The order which is challenged, my lords, is that reiterating that the mandate is extended because the pleadings.
29A.
No, my lords, it's not under 29A. May I take my lords to it, my lords. It's not an order per se. That's our first contention.
The mandate is only extended under 29A.
Yes, my lords, the mandate is only extended under 29A. Can I take my lords to the impugned order, which is at page number 34?
Yes.
My lords, the order under challenge is at page number 36.
That's right. What does it say?
What it says is that, my lords, at page number 37 in the bottom quadrant, the amended, may I read, my lords? 37 bottom.
You were the claimant?
I was the respondent, my lords.
You were the respondent. Was there any counterclaim of yours?
Yes, my lords. I had a counterclaim, my lords, for which.
For the claimant?
They were the claimants, my lords, before the arbitration tribunal.
But tell us one thing, how is 226 maintainable?
Please, my lords. That is our first ground of contention, that the writ petition per se is not maintainable.
My lord,
You will rely upon which are those judgments?
my lord, my submission is the other side, my lord, has filed an application before the trial court, a petition seeking for extension of mandate. At earlier point in time, my lord, when this matter was stayed, they filed a CMP before this court. Now, in view of the judgment laid down by the Supreme Court, my lord, they have approached the trial court now. The matter is listed tomorrow. They themselves, my lord, admit
What is the matter before trial court?
seeking for extension of mandate under section 29A. They have served the copy to us.
Approached.
Yes, they have approached.
They've approached, my lords. But, my lords, what
They
is
themselves
happening?
admit that, my lord. Until that matter is disposed of, my lord.
Let the arbitration go
We
on.
require,
What is the arbitrator doing?
It's.
my lord, an application,
Minute, please.
my lord, an application for amendment is filed.
You
Once
are
the-
right. Today, till such time the mandate is extended, the arbitrator can't go ahead.
Yes, my lord, very much.
You're right?
Yes.
Has he fixed a date? Then why this petition then?
My lord, only after the stay was granted by this court, my lord, the arbitrator has not proceeded further.
Only after this court intervened and granted a stay, insofar as the writ is concerned, my lord, the arbitrator has not gone forward.
Now, what happened to 29A is still pending?
Pending, here they filed it, it's listed tomorrow. For the first time, we have been served with a copy.
That's after notice.
Yes,
Who had filed 29A?
it has been filed by the respondents.
29, we filed 29.
Tell us one thing now, today, insofar as this petition is concerned, this must go.
Yes, my lords.
That's right. Till such time that 29A is decided,
Yes,
how relevant would be these proceedings? Suppose the mandate is not given, extended.
Yes,
What
my lords.
follows?
Yeah. The arbitrator would be extended. Replace.
Functus officio,
yes,
everything will fall in place. This will also go.
Let's may
yes,
request.
ma'am.
I make one submission. That's my lords may turn to the order sheet, my lords, which is dated 25/4/2024. Learned friend is trying to say that my lords, stay has been granted. Stay was never granted by this court, my lords. All the court observed was, my lords may take the order dated 25/4/2024. That's after hearing the submissions for some time on the interim relief, having regard to the fact that respondent have filed an application for extension, so on. So hence the proceedings of the arbitral tribunal stands deferred till CMP number
What is
180.
CMP?
That's a civil miscellaneous petition. That's we had filed a,
Where is this pending? Is this 29A?
yes, my lords. At that point of time, my lords, the High Court had the jurisdiction, my lords. But after the vacation, my lords, Supreme Court said that it should go back to the commercial court or trial court. So, my lords, we had to withdraw that petition with the liberty to go before the commercial court, my lords. My lords, my only contention is that, my lords, at this point of time, my lords,
There is the stay.
decide.
In fact, there is no need for stay after this. When the mandate has expired and they have filed an application, you have filed an
Yes.
application at 29A. It's as good as a stay. You can't proceed till such time the time is extended.
That's the provision would say that, my lords, until the time is extended.
I know, you're
Yes.
right. These proceedings can continue.
Proceed. And my lords, it's at the penultimate stage. My lords, the conduct of the petitioner today, my lords, before this court and before the
The
arbitration.
date of hearing, but he, in any case, he is not going ahead with the arbitration.
He's not going ahead with the arbitration because of this particular deferred word, my lords.
What is that? Was which word?
The word deferred, paragraph number 2, last line.
In the meanwhile, the deferment of this matter, keeping in view the submission of the learned counsel for the petition. Adjourn the matter and to fix a date of hearing.
Paragraph number 2, my lords.
No, are you reading 25/7?
Yes, my lords, 25 April 2024, paragraph number 2 order.
Two, hence the proceeding or shall stand deferred. Is decided. This 180 is the or 29A,
29A, which we withdrew, my lords, and we went before the commercial court.
but for a, with a similar application.
Yes,
That's right, Mr. Chinnappa?
Yes, ma'am, that's what has happened.
So, but in any case, this is as good as a stay of this.
Yes, yes, it is a stay of the proceedings.
It is stay of the proceeding, but till such time the 29A
He
is
is
decided.
decided.
So then you get your 29A decided first. That's the best, no?
that's we,
There was, of course, not, there was some confusion earlier. Which court must you go to?
You know, that's what you were saying. After Supreme Court, I think the.
Again, the
went
matter had to go. Now, I think.
one
final-
vacation changed the entire equation, my lords.
Pardon?
One vacation, my lords, changed.
We don't know. By the time that is decided, it may change again.
Could be.
Best thing is you work out your 29A. That should be the way, although the proceedings can continue.
Can continue.
Yes, ma'am,
The
but
only thing
this,
because of this order,
at that point in
the
time,
stage of the proceedings,
it's at the stage of evidence, defendant's evidence or respondent's evidence.
Evidence has been closed, it's put down for final arguments.
Problem is, of course, it's closed means I think they didn't cross-examine the witness because
didn't
of the stand that they
cross-examine us.
took, that the proceedings had come to an end. What happened in this case slightly unique, Mullah. It is not a case where the proceedings,
although we were on this 20, how a writ petition is made.
writ petition, of course, in certain extraordinary circumstances.
Under such, some
This is
circumstances,
a slightly extraordinary circumstance.
there are extraordinary. Extraordinary, very, we don't know. What would be the extraordinary, but surely, you know, this is the normal process of, the arbitration proceeding. That's why I don't know what is.
That's why
here.
after hearing both parties not quote pass this order.
No, we say nothing.
I think
Say nothing.
anyway, we are cooperating, my lord, we'll
The
appear
thing
tomorrow.
is, 29A, the matter is coming up tomorrow.
Yes,
tomorrow.
tomorrow. That's the matter.
Work it out there. Possibly you may succeed 29A.
Yes, then of course, what we have.
That is succeeded, the mandate gets extended, possibly you. Work it out before the arbitrator and possibly this would also not survive.
Might not, I'll. So therefore I won't,
Huh?
we won't, those are my, at least my belief, my lord. But
You have been, your evidence has been closed.
my opportunity to cross-examine
Cross-examine
has
the
been closed now, but our cases, it couldn't have been closed or done anything with because there was no application under 29A. That's the reason. But that'll,
That we say nothing on that.
Yes,
We will cross the bridge when we reach. But today, you pursue there, we'll have it after 2 weeks.
That's my request, one thing, that's because I'm sure the answer and his clients will not. That's, we have filed a 29A application there. That's, let there be a direction, that's so far as it be completed in a time-bound manner within a week or two.
No, see, you have filed your reply there.
No,
no, first time we have to appear is tomorrow.
Yes, first appearance
First
tomorrow.
date is tomorrow.
That's why I'm not.
But
saying-
my learned friend can take it from me that we will not unnecessarily delay it. We may take a week to file our reply, but
But we
nothing
will
more than that.
oppose that.
We may or may not oppose, but I'll speak to them.
So just wait, let's possibly take a date, pursue your remedy there. Okay. Just re-notify on joint request.
I think that interim order may continue, my lord.
In order to continue. In order, if any, to continue.
Yes, great.
2810, sir.
That's may again persuade my lords to at least say that it may be completed within
See,
2 weeks. It's,
I don't think there would be any purpose of arguing this matter today.
no, not this
Since
matter.
such time
lords.
that 29A is decided.
I'm saying that, my lords, I'm requesting
We
29.
will not. That you make your request to the authorities. He has not even issued notice.
No, notice has been issued
Have to.
by post. By hand, we served it.
Heard Mr. Chinnappa,
No, that's because I only served today by hand. I got it served, I not to you, sir. You're correct.
If he says.
If you got it, will come appear tomorrow, don't worry.
Says within 1 week, he'll file your reply, get the date fixed after 10 days, work it out, argue the matter. You don't require evidence, nothing of that.
Nothing.
Yes,
No, no,
yes, not at all. Grateful minutes.
Thank you.
29, Shri Jaikar Shetty.
Hmm.
2810.
Yes.
This case, my lord, last occasion, your lordship asked me to verify whether he is getting the in charge post scale or,
Yes.
please, madam.
That on the date of retirement, I was getting a higher pay, that should be the basis for my retirement.
Yes.
No, in fact, my lord, I have verified, he has been paid the very same post salary.
Which post?
That is a director program.
JG.
You don't know then. This so then why is he not retired? It's simple.
No, he has retired, my lord. Please.
He's seeking pension of that.
Yes.
No, he is getting it, my lord. By way of MACP, my lord, he got it the similar scale, my lord.
Case that he is getting pension on the basis of pay he was drawing as JAG. Is it your case also, Mr. Hola?
Yes, my lord.
Then what remains?
No, he has filed writ petition, my lord. That's why I'm
In fact,
surprised. Why he has
he-
filed writ petition?
Tribunal order created some trouble, my lord, because in more than one words, it's he is entitled for eligible for.
The tribunal will consider it. Who your governments have been paid. If this is so, this is his grievance. You are paying him. Neither he should have any grievance. neither you
That
should
is
have
what I have verified, my lord.
I have no grievance, my lord. Only, I have approached the tribunal, my lord, asking for promotion retrospectively. That has been rejected. Matter is over there.
But now you are getting pension on the basis of JAG.
Yes.
Now let's see what does the tribunal say.
Please. 135,
136.
137 is the relevant. One three seven.
Tell us, Mr. Holla, what is the purport of this order of the tribunal?
Tribunal says, my lord, applicant is eligible for notional fixation of pay with effect from 9/10/2022, and it will have effect on the pensionary benefits. Pensionary benefits are paid, my lord, as per, I have been working from 2012 as in the post of JAG.
Which date that pay was being given as JAG?
Yes,
No, now tell us one thing, did you actually get the pay of JAG
yes, my lord.
or notional, was it a notional fixation?
No, notional fixation subsequently, my lord, subsequent to his retirement.
I will just pass on, my lord.
Notional fixation after retirement.
My lord, I am not
No.
able to understand this order.
No, it's
No,
not
the
on notional
last
fixation,
sentence
my lord.
create confusion, my lord, but then during the interim applicant cannot
Due to
provide any extra
MACP,
pay
my
as he
lord,
has not
granting of
actually
MACP, he got it, my lord. Not notional fixation.
We have understood is this. The tribunal proceeds on the premise that he is not promoted, he is not getting the pay of that post. We will say right. See the second line, the applicant was appointed to higher position temporarily on 9/10/2012. As the DTC could not be held for some technical reason. He held the position till 34/13 and he retired. Thereafter, having resolved the issue, the DPC was held on this. But then, since he has already retired, the benefit could not be conferred on him. The applicant claimed the notional benefit may be granted to him from the date on which he was shouldering the burden of the new assignment. Now, full stop.
Yes, ma'am.
This tribunal says as if he did not get the higher pay of that post, which is, according to you, he was actually drawing.
Yes, my lord.
Then this submission, the manner in which the tribunal proceeds is on a wrong premise. How, you are drawing, but then why does the tribunal say notional?
Not notional, my lord. By way of MACP, my lord, he got the that scale, my lord. But it, in fact, my lord, balances with now the present in charge post. Now nobody is having unless notional is fixed. We are having a grievance over notion because this creates, my lord, next, my lord, 9/10, next sentence, my lord. It is that is the same order, my lord, your lordship.
How does it start, the line?
It is in compliance with the rules and
It is in compliance with the rules.
natural just as the applicant is eligible and suitable for promotion as on. And he had discharged duties till his retirement. Applicant is liable for notional fixation.
We will only say this.
Please, my lord,
Your claim for promotion was rejected.
Yes, that's
You have not challenged that.
Challenge.
order.
No,
That attained finality.
yes,
We will record your submission also as a JAG.
yes, my lord.
You got the JAG on 9/10/2012.
Yes, ma'am.
That's right.
please.
So you were drawing the pay of JAG. You have retired, your pension has been fixed on the basis of JAG.
Let him say that, my lord, because he is the pension.
Not on JAG, my lord. That is the point, my lord.
Whatever
In fact,
it
my
is.
lord,
It's your pension on the basis of JAG.
My lord, absolutely, I have no grievance about this.
No, I
order,
will-
my
I will-
lord. But whether he's getting as per the JAG or
No, he is-
MACP, and why should I commit with not knowing the facts? Because
So wait, what is the scale you were drawing on the date of retirement?
no, I will just pass on, my lord, the relevant papers.
he retired in 2013, my lord, after 11 years. I mean, he has not met me for last 6 years. Also.
Not that complicated JAG. You can say on this scale, he retired
Yes, ma'am.
and he has been given pension on that scale. Whether you got it through JAG or MACP.
MACP, that is the only point.
Yes,
But nobody is having grievance now, man.
You are getting a higher proper pension based on the pay which you are drawing.
Please.
yes, my lord. He has given the fair fixation statement also now.
So under this order, my lord, he has got, my lord, the pay fixation, that is 3, my lord, serial number 3.
pay band, that is grade pay on getting third MSCP on 1/9/2008. So 15,600, 39,100. The grade pay is 7,600. Now he is getting that.
The present petition has been filed by the appellants challenging the order of the Central Administrative Tribunal dated 4th October 2019, wherein the tribunal has stated that so the people of the petitioner, the grievance of the respondent before the tribunal was for a grant of promotion in the junior administrative grade. Where are the prayers? Junior administrative, was for promotion.
Yes, madam.
Was for promotion in the junior administrative grade.
His prayer is at page 24, my lord.
23.
So that's a big prayer, I think, very difficult to understand also. To direct the first respondent to grant DDG Director G grade.
2016. First off, the and with all is it 23/4/2016 or 12/4/2013? How would you get from 16 when you are retired?
He retired in 2013, my lord.
This prayer 23/4/2016, how did you get it?
That is the DPC convened, my lord, 13/4/2016, and by the time he has already retired. That is why he is not entitled.
JAG with effect from 5/5/2011. Say 5/5/2011. With all consequential and financial benefits. It's a conceded position that the petitioner, the respondent had retired on the date of retirement.
34/2012.
2013.
No, that is a order, my lord. In fact, effect from
Had retired on 34/2015.
please, A5, as per A5 is clear.
The tribunal has not. The tribunal did a order dated, so the tribunal in terms of the impute order. Has observed that the petition, that the respondent is eligible for promotion. As on 9/10/2012. Mr. The grievance of the appellant is primarily that the said order, said direction could not have been given by the tribunal. Mr. On the last date of hearing, we had passed the following order. Which when the counsel for the appellant submit that the appellant had got the scale of rupees was the scale of rupees 3,600 -391,000 or 00.
That's a pay band.
No,
That's a pay band with the
Grade pay of
that's 600.
as an MBCP. As an MBCP. It, according to the council, the grant of the said scale must not be construed to mean that, cannot be construed to mean that the petitioner got the benefit of, was given the grade of junior administrative grade, or was promoted as junior administrative grade. Junior administrative grade. In any case, he submits that the respondent's pension has been fixed on the basis of the FSS scale on the date of retirement. Mr. Holal and a counsel appearing for the respondent does not dispute the opposite position. So if that be so, then what is the grievance you have?
I don't have, my lord, he has to answer.
If that is, no, see, there is one observation of the particular Mr. Gupta. It says that he should be given promotion from that 9/10/2020.
No, my lord, tribunal says that he was not promoted and what with that post, therefore he cannot get that pay. Order says that.
There is a total, the order is not so happily worded. One is specific query to Mr. Ola. Does any grievance survives for the petitioner to have approached the central administrative tribunal? The answer is in the negative.
Yes.
Right? It's coming that way. So we clarify that the respondent had never, the respondent is not aggrieved by his non-promotion to the post of junior administrative grade. Sure?
Yes.
We are recording it. Junior administrative. So his only plea was, his only plea as noted on the last date of hearing is that the pension must be fixed on the basis of the salary drawn on the date of retirement.
Yes, ma'am, that's all.
In view of this submission made by the London Council for the appellants, that the respondent is drawing the pension, the pension of the respondent has been fixed on the basis of the salary drawn by him on 30/4/2013. Nothing further survives in the petition.
Yes.
So, thank you.
Serial number 30. Karnataka.
Applicants petition. Not the petitioner, my lord, was an employee of the government of India, Department of Survey of India. Lord, he has retired from service, my lord, on 30/9/1996. As on the date of retirement, he was holding the designation of a superintendent. Lord, Fifth Pay Commission's recommendation was given retrospective effect with effect from 1/1/1996. Thereby, my lord, that his pension earlier it was settled. Then, my lord, that in the light of the recommendation made by the Fifth Pay Commission, Central Pay Commission, my lord, then the recommendation was also made for refixation of this pay under the revised pay scale. Then what had happened was, my lord, that has not been done. Thereby, my lord, that the petitioner has approached the tribunal, my lord, after making all internal correspondence with the department. The tribunal, my lord, has rejected my application only on the short down. The rules are silent regarding, though this commission has recommended the upgradation of the pay, but that is not forthcoming. That is not there in the rules. Thereby, my lord, it is not possible to extend the benefits sought by the. That is the only ground under which, my lord, the tribunal. My lord, my only submission is this, my lord. You will also kindly see, my lord, that the official memorandum issued by the government of India, page 267.
1600 upgraded to 16.
Yes. 1,000, not that, is lost on basic, my lord, as on the date of his retirement. It was 2,150.
What is the replacement scale of 1600? What was the replacement scale?
Replacement should have been on the 1,640.
That's upgrade.
Upgradation.
Normal replacement to 5,000, 8,000.
That's the reason why your lordship kindly see, my lord. I will show it to you. Your lordship kindly see, my lord. Page 269, my lord. The part A, my lord, annexure to lordship got. Page 269. Lord, serial number 10, your lordship got.
That's the upgrade.
Yes, my lord. This is, my lord, that the existing scale of the pay, 1,640,
Yes.
not 2,900. Lord, this is, my lord, the revised scale of pay is 5,500, 175, 9,000.
What you were getting was 1600.
Yes,
That's right.
it was on the, yes, man, in the pay scale of 1600, my lord, I was getting the last on basic, my lord, the basic pay was at rupees,
5,000, 8,000 is the limit.
is how?
Now, when it is said upgraded, the pay is upgraded to 1640.
Yes,
Okay. The date of implementation is 1/1.
1996.
1996. So on that day, you have to be given the revised scale.
The
1/1/96.
revised scale is, my lord, that the 5,500, 9,000. That is the revised scale. But the
Scale of the upgraded scale.
upgraded scale is 1,640. That has not been given is my grievance.
If you look into perspective, on 1/1/96, in terms of the recommendation of the fifth CPC, instead of 1600, it was decided you will be given 1640. That's the
Please.
upgraded.
Please.
But that 1640 would be in terms of the recommendation of the fifth CPC, which means that on 1/1/96, we are upgrading your scale from 1640 to 1600 to 1640. But it necessarily follows whatever is the replacement of 1640, that is 5,500, would be given to you on 1/1/96.
My lord, what happens is, my lord, your lordship kindly say annexure, which your lordship kindly. In fact, this was recommended.
Let's assume what you are saying is right.
Annexure A5, my lord, your lordship kindly, how the authorities have recommended it. Yes, there was a recommended annexure. Annexure Annexure 5, my lord, page 51. Page 51, my lord, 51. The comparative statement, what they again statement, my lord, paragraph, the details of the pay fixed in the scale of pay, 5,500, 175, and what should have been the pay had it been fixed in the scale, in the scale of pay of 5,000, 150 and 8,000 are furnished below. Well, my lord, the pay fixed in the scale of pay 5,500, then my lord, revised the revised scale is 6,550. Again, my lord, 5,000 to 8,000. This is 6,000 rupees, 6,650. Difference between A and B is rupees 100. Then, my lord, next page, the revised pay scale of 5,500, 175, 900, 9,000 approved for the post of office superintendent in our department is actually replacement of next page 52. Yes.
That's right.
Yes, fair enough.
Now, on 1/1/96, can there be a fixation in a pre-revised scale of 1640? It cannot be. What the effect of the upgraded scale need to be given on 1/1/96?
Look,
On 1/1/96, the recommendations have been given effect to. That means all revised scales, including the revised scale of that upgraded scale which you have got of 1640, it would be fixed in that. Otherwise, it would be an anomaly.
Lord, my submission is that this should have been since he has already retired. But my lord, that the notional pay fixation should have been done because, my lord,
We will ask you how will it be done. Tell us. Now, let's assume a situation. On 1/1/96, you will fix in 1640. On 1/1/96, you will also fix in 5,500. Is it possible on the same day, two fixations? See, read 5. Read 5. Under the above circumstances,
we presume that the pay of Sri Rajendra first should be fixed notionally in the pre-revised scale of pay of rupees 1640, 2,900 on 1/1/1996 before his pay is fixed in the revised scale of pay of 5,500, 175, 9,000. Otherwise, there is a loss of 100 rupees per month in his basic.
but on which date this 5,500, 9,000 will be fixed?
This has to be from 1/1/1996.
How can there be two fixations on the same day?
Well, how think, Milan, that the rule 4 has been extracted here, Your Lordship.
Intent is this of the pay commission recommendations. Before 1196, you were drawing 1600. The recommendation says no, henceforth it should be equivalent to 1640. We are upgrading the scale to 1640 under the fifth pay commission. So when fifth pay commission, the pay fixation is fixed, or the pay is fixed on 1196, they will see what is the revised scale of 1640, 2900, that is 5500, and fix that on 1196. Otherwise, let us put it this way, otherwise 1640 must relate back to fourth pay commission. Because this 1640 had actually origin was on 1186.
That is in the pay scale, my lord, the pay scale is 1,660 to 2,900 is, my lord, at the pay scale. But what was drawing is, he was drawing was 2,150. My lord, this has been, my lord, as clarified, my lord. I extracted it, my lord. Annexure 4, page 49. My lord, that the rule 4 has been extracted here. May permit me to read this, my lord. Paragraph 2, your lordship, kindly. Right.
Does an employee has an option? Let's assume not in this case. Suppose my date of increment is 1196. Under the old re-revise 1196. I say, don't fix the pay on 1196. You give me increment on 1196 under the pre-revise. Okay? And then fix my pay in the revised scale.
My lord, there are 3 categories, my lord. The superintendent, then my lord, the other 2 categories, my lord, staff, junior assistants and other. My lord, how, my lord, this has been recommended in respect of other categories are concerned is also forthcoming. I will.
They also was an upgradation.
They have given it, my lord, notionally. Upgradation in the 100 rupees, my lord, till these, all these things are clarified. And 100 rupees been added and they have given it. I will show it here. Annexure.
What he is saying is, in a similar situation, not in this post, on a different post, with a different scale.
Yes.
There is an upgradation of the pre-revised scale. You have given the benefit. First fixing the pay in the upgraded scale of the pre-revised, and then gave the revised scale. That's what you are saying.
Annexure B, page 84. The typed copy is 85. May I read this? Special pay of 100 rupees may be continued to be granted to those performing higher duties, those who are given to the post. The upgradation of the revised pay scales notified at page 112 against the Survey of India. In the first schedule, part C of the Ministry of Finance Gazette notification dated 30/9/1997 may be implemented in respect of the office superintendent, clerks, assistant, stores assistant. Accordingly, the replacement scale of the pay in respect of these posts will be as follows. Office superintendent, then head clerks, assistant doors. The pay fixation of all the survey may be done in the replacement of the scale given to the fifth CPC 5,000, 8,000 for the pay of rupees 4,400, 2,000 existing scale of surveyors until the modified scale in respect of 30% of the higher grade surveyors are implemented. Special pay of rupees 100 rupees per month may be continued to be granted for those performing the higher duties than those given to those posts. These orders have been issued in consultation with the approval of the Department of Science and Technology.
But in fact, the party person has conducted the case before the tribunal. But he instructed me saying that, my lord, except superintendent, other two categories are concerned, my lord, that has been granted. That's what I was told. Other two categories means, my lord, that the clerk's assistants and surveyors and stores assistants.
No, my lord, only for this one, separate schedule is there, schedule C. Separately they have mentioned, my lord, for the superintendent, survey superintendent.
But there is an upgraded scale. If you first fix in the upgraded scale, then give the revised scale. What he said is 1600 became 1640.
Yes.
You first fixed my pay on 1640 on 1196. Then thereafter revise it.
Yes.
Revise in 5,500, 9,000. That's his case.
My lord, as on the retirement day, what was he was drawing? On that base only?
The date of retirement. He's talking about 1196. He's talking how pay need to be fixed. See, what has happened in his case is he was drawing 1600. What is that? 20%?
Yes, but in the pay scale of, my lord, 2,150, in the pay scale of 1,640, 2,900.
No. What is 1600?
The 16 is the pay scale, my lord. 1,600.
How much 1600? How much is that?
Yes,
That is 1600. 2,660. 1600, 2660. He was drawing on 31/12, 1995. He says on 1196 recommendations have come. His scale has been upgraded of this post from 1600 2660 to 1640 2900.
Yes.
So he says you first fix me on 1640. The pay. Then you will convert me into the revised scale of 5,500, which is the replacement scale of 1640. The tribunal rejects it. Tribunal says upgradation is a recommendation to 1640 on 1/1/1996. Whatever is the replacement scale of 1640, that will be given.
Yes.
That is what?
Yes. Moreover, 23 years delay also, my lord. Right? Yeah. No. Yes. No, but rightly observed by the tribunal, my lord.
Yes.
Page 266.
Okay, there will be two fixations on the same day. One is in 1640, second is in 5,001.
My lord, how, my lord, things has to be implemented. My lord, your lordship kindly, this document was marked as exhibit P1 before the tribunal. Page 266, my lord. 66.
606.
Yes, ma'am. 266.
Please give us. Yes.
Lord, may I make one submission, Lord? Because since I was told saying that in respect of other than this category, surveys and others, Lord, upgradation was done, Lord. Lord, my only request is, Lord, let my Lord find out. I am also on the ground of discrimination. Find out. If that is not there, my Lord, that maybe
No, my
let them
lord,
find out from the department.
page number 283 of the
Only the
tribunal
difference
order,
is
para 14, my lord, observed regarding. At page 283, para 14. 13 I will read, my lord. As per the rules, pay revision has to be done from the existing pre-revised pay scale to the revised pay scale as recommendation by the 5th Central Pay Commission. There is no provision in these.
That's what.
This would imply grant of separate pay fixation.
Yes.
Can't be. See, the presumption is, I am upgrading it. You will not be entitled to the normal revision of 1600, but you will be entitled to a revision of 1640 on 1196. I don't think you should really.
Let my Lord find out, my Lord, Lordship, kindly have it on Monday.
Similarly,
Please.
where upgraded scale has been given. The fixation was done in the upgraded scale first, re-revised, then the revised scale was given.
Yes, that has been done, I was told in surveyor.
Yes.
Which is this department? Is this surveyor?
In same department.
Yes, yes, ma'am. I will also.
You'll have it from Monday.
Please.
No, ma'am. 1 week, one week, my lord, after 1 week. After 1 week, at least 1 week.
For the respondents to take instruction as to whether the prayer made by the petitioner in the petition before the tribunal was granted in favor of certain persons on the post of
Survey.
The post of surveyor.
One week.
Sir, 14, sir, 14.
14.
14.
Wednesday.
Pardon?
Wednesday, my lord.
14, sir.
14.
Please.
31. Vijay Kumar.
Yes, Mr. Kamala. This.
Petitioner was working as a biochemist in National Institute of England. And for the petitioner.
My lords, I appear for respondent number 2, my lords.
Yes.
But the petitioner was working as a biochemist in the National Institute of Unani Medicine. Unani Medicine, my lord. But as per the C&R rules, there is no provision for promotion from the post of biochemist. But she therefore submitted a representation having rendered more than 15 years of service. She submitted a representation requesting to extend her the benefit of in situ promotion.
Which promotion?
In situ scheme, my lord. In situ scheme, she made a representation, my lord, that was not considered. She therefore approached the tribunal. The tribunal initially directed them to consider the representation. But her claim was rejected on the ground that the post of biochemist is not a scientist post and she is not doing any teaching work. But she placed material before the respondent to show that she is doing both research as well as, my lord, teaching work, my lord. But
For scientific research.
that initially it was, my lord, but subsequently it was modified and, my lord, it was extended to non-teaching and technical posts.
Is it a technical post?
It is a technical post,
But what are now is it a isolated post?
isolated post, no promotion.
No ACP.
No
ACP
AC.
is given.
I am seeking for this one, my lord, in situ, which is,
It is also a financial.
yes,
But did you get the benefit of ACP to the next scale?
no, my lord. My lord, I have been extended the MACP scheme, my lord. I was being brought under MACP, my lord, which is not for technical officials.
But you accept that?
No, I have not. I have been repeatedly, my lord, requesting since 2017, my lord, to extend the benefit of in situ. Now, my lord, by the impugned endorsement, my lord, they rejected my my claim only on the ground that it is not a scientific post and you are not doing any research work. Now, the tribunal now comes to the conclusion that, my lord, the post of biochemist in NIEM is not included in the in situ schedule and therefore I am not entitled.
You got MACP.
My lord, MACP I have rejected, refused, my lord, for the simple reason that it cannot be extended to me for the reason that I am holding a technical post.
But what is the difficulty for you to accept the MACP?
My lord, there, my lord, the upgradation is every 10 years. Here, my lord, it is every 5 years.
Where is the institute scheme?
My lord, I have produced along with the representation, my lord, along with the application, my lord. That is at page 265, my lord. The original notification I'll be permitted to pass on, my lord. It will be easy. Only one copy. This is the original notification.
Is it that has been extended to technical?
Blood, that is at page. But explanation to the memorandum, Lord, that is in the second. Lord, in the Lord, page 270 in the petition, my lord. Flush. 270, my lord. Clause 12, my lord. Below that, my lord, explanatory memorandum to the Department of Health, Group A, guested non-medical, scientific and technical posts in situ promotion. And this has been adopted by Ayush, my lord, where I am, the Ayush is under which, my lord, NIUM comes. That, my lord, I have produced. Lordship will get it at page 149, man. By a Karnataka, my lord, this has been made applicable to Ayush. And the NIM is controlled by Ayush. Please.
The scientific post in Ayush.
Hello?
The scientific post in Ayush.
Please, my lord.
Okay, and see the qualifications. This who are working in CCRS, CCIBM. Now, is it your designation of a scientist?
No, that is treated as equivalent to scientist, my lord. In the in situ, my lord, your lordship may kindly see.
Which one? Show us. Now, minimum qualification, master's degree in science, bachelor's degree in engineering.
I have PhD degree, my lord.
For non-medical, medical doctor, bachelor's degree.
My lord, page 274. In the notification, my lord, it is clear. Page 274, my lord, miscellaneous, biochemist, 1, my lord. Which has been included as a scientist, equivalent to scientist grade.
Which one?
Biochemist, my lord.
Chemist.
Yes. In the miscellaneous, yes. Ma'am.
But why does the tribunal say that it is, this is the old scheme?
No, this is still in force, madam. I mean, this was this.
For the,
But initially, it was issued for the Central Institute, my lord. Subsequently,
this is by Ministry of Health.
yes,
What is your designation?
not biochemist. That the same scheme is adopted for even All India Institute of Medical Science also, my lord, where a biochemistry is, my lord, being extended the in situ promotion. The tribunal rejects my claim only on the ground, my lord, that the post of biochemist in NIUM is not included in the schedule. Biochemist qualification and what the qualification I have is the one, the similar qualification the biochemist working in All India Institute of Medical Science also has. Where that benefit has been extended.
Yes, what do you say? Yes, what do you say?
My lords, I'm appearing on behalf of the panel council, my lords. May I request for a short accommodation, my lords? I'm sorry I had to inform in the earlier, but didn't want to interject.
You appear. You appear for him.
No, I am appearing as a proxy counsel for
For
respondent.
him.
No, respondent number 1, the union.
Now, who is the contesting party? Is the
The first
Unani
respondent,
Medical?
government man.
You appear for R1.
Yes, I'm.
You appear for R2.
Please, my lord.
Have it some other day, then let him get. At the request of counsel for respondent number 2, we notify.
11-9, sir.
Shorter date, man. Shorter date, my lord. Please.
How many are there, man? Just call. Which is the last man? Yes. What is this, Mr. Shetty?
This, my lord, with regard to the notional promotion, my lord, that is a grade pay, my lord, he wants it. From 1/9/2008 to to 31/12/2000. The only point here is, my lord, whether the grade pay is the basis for claim or a post is a claim is a question, my lord. In fact, my lord,
What is the earlier judgment?
earlier judgment, my lord, that is at page 69, my lord, in page. Subramaniam case.
Let's see. This is- Submit the petition. And the previous matter.
Only point here is, my lord.
Just 1 minute, Mr. Chet.
Please.
Detention.
He was getting a grade pay of 4,800. So for 4 years he has worked. So the next grade is 5,400. So he is entitled for that 5,400 from 1/9/2012. That is his case, my lord. Our case is, my lord, the getting the grade
But
pay
what
is not
what
a
is that
criteria.
judgment? What is the judgment in 284? Where is it?
That is, my lord, in Subramaniam case, my lord.
Where is that?
That is in page 73, 69. In page 69. So, different department, my lord, that is one of our contention also. But there, my lord, one more point is, my lord, in this, my lord, our department, petitioner's department, there is an order, my lord, that is OM, that is coming in the way of granting this benefit, my lord. There, my lord, it has been specifically stated. So in these cases, my lord, that has not been discussed or that has not been come into picture also, because this is a Prasar Bharati, my lord. There they were, so they have interpreted that.
See,
One more
5,400 is given after 4 years in 4,800. Now, was he in 4,800? Was it in grade pay of 4,800?
Please, my
Yes,
lord.
madam, yes.
He was there, but here, my lord, post is important. That is our case. Because pink page 135, my lord, there is an order, my lord, that's OM. It says, my lord, he has to hold a post of senior administrative officer.
How did he get this 4,800? ACP?
By way of
ACP and
ACP.
MACP.
Then, Mr. Hola, how would you justify?
Well, I'll come to that. Well, before that, I'll take your lordship to relevant rules. Page 155 is the Gazette notification. At page, my lord.
There is a judgment of the Supreme Court in this issue.
This has been upheld. Madras High Court decision has been upheld by the Supreme Court, my lord. Subramaniam case.
Which one?
Subramaniam's case. That arises only also out of ACP. Now kindly see the rules, my lord. First, let us go to the rules. Page 157, my lord. Page 156. My lord, the following pay bands recommended by the commission will be improved and modified pay bands will be as below. Now kindly come to the next page, my lord. Roman number 10, small 10, clause E at page 159. Group B officers of a Department of Posts, Revenue, etc. will be granted grade pay of rupees 5,400 in PB2 on non-functional basis after 4 years of regular service in the grade pay of rupees 4,800 in PB2. It is nothing, it is related nothing to the post, my lord. It is the consequences of the pay revision, improvements in pay revision as per the 6th Pay Commission. Now I take your lordship to the Madras High Court judgment in Subramaniam's case, my lord. Only I read the relevant paras, my lord. Kindly turn to page 71, para 6, my lord. 3 paras I will read now. It is not in dispute that the Government of India, by its resolution dated 29/8/2008, just shown, granted grade pay of rupees 5,400 in pay band 2 on non-functional basis to the Group B officers of the Department of Posts, Revenue, etc., who completed 4 years of regular service in the grade pay of rupees 4,800 in pay band 2. According to the petitioner, he has already reached the pay scale of rupees 7,500, 250, 12,000 by way of ACP scheme on 1/1/2004, which is corresponding to the pay scale of Superintendent of Central Excise Group B post. And therefore, on completion of 4 years, he is entitled to the grade pay of rupees 5,400 with effect from 1/1/2008. In support of his claim, the petitioner also relied upon a clarification issued by the Central Board of Excise and Customs letter number so and so dated 21/11/2008, clarifying that the 4-year period is to be counted from the date on which an officer is placed in the pay scale of rupees 7,500, 12,000. However, the claim of the petitioner was denied based on the clarification issued by the Central Board of Excise and Customs dated 11/2/2009, wherein I'm sorry.
your permission, one request, your lordship. May I request for hand delivery also, because the SPP
Yes.
office will intimate them, but they want a certified copy to be passed.
Pardon?
They want the
This one
certified copy
correction.
and requesting for hand delivery of the order.
It goes like an email also. We will do it. No? We will sign it, ma'am. Just get it processed. Whatever will be processed. We'll send it email also.
Very well.
I think that's the process also.
Yes, that's the problem. Wait, may I request for hand delivery?
We'll send some. We'll just sign it here. We'll just go.
Very, I'm grateful.
Absolutely. Corrected. Very good. It's only picture. Yeah.
Great, great.
Yes, Mr. Ola.
My lord, I read from para 6, my lord. It is not in dispute that the government of India by the resolution dated 29/8/2008 granted great pay of ₹5,400 in pay band 2 on non-functional basis to the Group B officers of the Department of Posts, Revenue, etc., who completed 4 years of regular service in the great pay of ₹4,800 in pay band 2. According to the petitioner, he has already reached the pay scale of ₹7,500 to ₹12,000 by way of ACP scheme on 1/1/2004, which is corresponding to the pay scale of Superintendent of Central Excise Group B post. And therefore, on completion of 4 years, he is entitled to the grade pay of ₹5,400 with effect from 1/1/2008. In support of his claim, the petitioner also relied upon clarification issued by the Central Board of Excise and Customs, letter number so and so dated 21/11/2008, clarifying that the 4-year period is to be counted from the date on which an officer is placed in the pay scale of ₹7,500, 12,000. However, the claim of the petitioner was denied because on the clarification issued by the Central Board of Excise and Customs dated 11/2/2009, wherein it was clarified that the officers who got revised pay scale of 7,500, 12,000 corresponding to the grade pay of ₹4,800 by virtue of financial upgradation under ACP would not be entitled to the benefit of further non-functional upgradation to the re-revised pay scale of ₹8,000, 13,500 corresponding to the grade pay of ₹5,400.
They are right.
No, right, this is next, my lord. We are unable to agree with this clarification given by the Under Secretary to Government of India.
This is in Subramaniam's case.
Yes, my lord. Ultimately, it has held even ACP and MACP, whatever it may be, regular service counted there.
This, okay, we will see, we will have it next week or so. We'll look into it. See that 5,000 fine, 400 is non-functional.
No, in CIT, a number of cases have been disposed of based on Subramaniam's case.
We will see that. To my recollection, possibly I have also given one judgment. I want to see that.
Yes, very well, ma'am.
You also look.
Please.
No, we are citing this decision, Subramaniam's decision, number of cases there in CIT.
Possibly, maybe I have followed it also, possibly.
Very well, madam.
We'll have it. Ma'am, how many matters more?
3 minutes.
Yes. We will adjourn it. We'll adjourn it. Are we to say that it is by hand delivery? Which is the menu?
ಇಲ್ಲ ಕೊಡ್ಲಿಲ್ಲ ಮೇಲ್ ಮಾಡ್ತೀರಾ ಅಂತ
Do that. Do that. Should you do that? Just tell him also.
Lordship, serial number 12 was passed over. Morning. Date may be fixed.
I apologize, my lord, I was on my legs.
There's another service matter, my lord, inter se seniority related.
A date may be fixed, my lord.
Who is the other side? There was someone appear in the morning.
Junior adult.
My colleague had sought for a
That
passer.
appeared. Okay. Okay, okay. You appear for the petitioner.
Petitioner, please, my lord.
Just read, we'll fix up a date.
Please.
My lord, for serial number 33 also kindly take.
We'll give you a date.